Good morning, everyone, and welcome to the annual symposium brought to you by the University of Richmond Law Review. We're delighted to have you here this morning. In particular, if we have any of our wonderful alums in the audience, I see that we do. Welcome back. It's great to have you here. And if you, at one of the breaks, if you have a few minutes and want to take a stroll through the building and enjoy the beautiful renovation, we're delighted to give you the opportunity to do that. Today, the Law Review has brought together an impressive group of speakers and scholars to explore the interrelationship between politics, economics, and law. Law and political economy offers a critical lens through which to explore law's impact. It's an effort to look beyond the seemingly neutral rules and the ways in which seemingly neutral law can conceal the political aspects of the markets. Today's speakers will focus in particular on labor force, care workers, and those impacted by the criminal justice system, an attempt to peel back some of those seemingly invisible components of the legal infrastructure that shape the exploitative results of the economy. Promises to be a fascinating discussion. If all goes well, it may even cause some people to re-examine views they've held for a while. That would be a good thing. So again, we welcome you to Richmond Law and hope you have a terrific day here at this symposium. And now, please join me in welcoming the Law Review Symposium editor to tell you more about today's agenda, Alyssa Harrison.
Thank you, Dean Perdue, and good morning, everyone. I would like to welcome all of you again to the University of Richmond Law Review's Fall 2024 Symposium, Economies of Extraction, Labor, Care, and the Carceral State. Again, my name is Alyssa Harrison, and I have the great pleasure and honor to serve as the symposium editor for the Law Review Volume 59 Executive Board. I also have had the very great pleasure of planning this event, so if you guys like the menu, let me know. There's a lot of thought put into it. There's likely more than one person in the audience today what extraction means, what law and political economy might be, and how both are even relevant to their own practice and lives. It's hard to cover all of that in a few minutes, but I'm going to do my very best. Law gives shape to the relations between politics and the economy at every point. In other words, there's always a tension between politics and economics, and our legal processes and systems mediate that relationship. Much of legal scholarship and practice in recent decades has held politics and economics apart, or even actively thought of as being about the economy. This might be torts, antitrust, intellectual property, and consumer protection. Public law scholarship, on the other hand, makes the economy an abstract concept. An example of that can be seen with constitutional law, which often asserts that constitutional values have no bearing on questions of economy or class. Law and political economy, also known as LPE, we'll probably be using that acronym pretty often throughout the program, is a critical approach to law that focuses on how supposedly neutral legal rules shape economic power, disguise its inequalities, and insulate the economy from democratic control. LPE believes that the last several decades in legal scholarship and policy helped facilitate rising inequality and precarity, political alienation, and the entrenchment of racial hierarchies that we see on an everyday basis. Under these conditions, the LPE framework offers a set of tools for thinking about the way that certain neoliberal assumptions have been absorbed into legal common sense. One way we'll be doing that today is looking at extraction and how legal frameworks around extraction often exacerbate social and economic inequality. What is extraction? It's been all over the branding. You probably have a couple questions what that might be looking like today. Per typical economic thought, when someone works, it creates capital or wealth. But all too often, that wealth and capital these days doesn't go to the actual person doing that work. In fact, people who do some of our hardest work, care workers, independent contractors, teachers, and incarcerated individuals, see their labor marginalized and devalued. That, in essence, is extraction, and extraction is protected by legal systems in place today. LPE seeks to articulate alternatives for a more sustainable and democratic political economy, and at its heart, this symposium hopes to do the same. Today, we seek to reconnect political conversations about economic order with questions of dignity and belonging, particularly for those who are the most vulnerable and marginalized by our politics. We also seek to offer concrete legal reforms designed to move beyond neoliberalism and toward a genuinely responsive, egalitarian democracy, with critical attention to the need for power and movement building as part of any such transformation. Some might argue that this symposium is overcritical or even too political, but if we believe such critiques are integral to hope, because hope is a practice at the end of the day, and it's not something that's often taught in law schools. If we think realistically about the ways that another world is possible, we must understand the ways that our own has been made, with its hierarchies and harms, and to see how the same tools that might make it, remake it, into something new. To change the world, we must first understand it, and that begins by making it and ourselves less resistant to both change and understanding. We hope that this event calls attention to the harms we see around us and proposes a better way forward. To start us off, members of the Richmond Law faculty, Professors Aaron Collins, Marissa Jackson-So, Luke Norris, and Allison Tate, will share with us what extraction means to them in their respective fields and areas of research. Professor Yiren Zhang from Cornell will then discuss the gender and political economy of home-based care work. Next, Professor Gali Rakabi from Cornell will talk about how the Equal Protection Doctrine impacts work laws exclusions. We'll break for lunch probably around 12:15. We have a lot of time built in to make sure we can stretch our legs and that sort of thing. And at 12:45, we'll return with a presentation from Mr. Danny Zemmel from the Crutis Law Firm to talk about the procedural hurdles in litigating on behalf of incarcerated people. In our final panel, we will have the opportunity to discuss the practical and ethical challenges in movement lawyering and organizing with Professor Cassie Powell of the Access to Justice Clinic here at Richmond Law, Ms. Anna Kirian of the Legal Aid Justice Center, and Mr. David Walrod from the Fairfax County Federation of Teachers. We'll wrap up the day with some concluding remarks, make sure that everyone gets their CLE credit, and then we'll send you on their way. A few topics that we will cover today might be ones that you disagree with or want to push back on. Disagreement is good. I think it fosters a healthy democratic society and dialogue. But as we go through today's program, I also hope you take the time to interrogate your own biases and assumptions. We all have the same goal, I think, at the end of the day here at a symposium, to grow and learn and become better legal professionals. I do hope that you listen and learn and question and think about what's being shared with you today. And when we all head home, I hope you ask yourself what you will do with what you've learned today. As a few reminders, if you have a housekeeping question or issue, find someone with a name tag like my own. We'd be happy to give directions or clarify any concerns. All sessions will have time for Q&A, so please reserve your comments for the end of each presentation. We'd love for the symposium to be ripe with discussion and engagement, and we're so excited to see so many of you with us today. Thank you again for being here today. I'm going to hand it over to our wonderful faculty for our first panel. Please join me in welcoming Professors Aaron Collins, Luke Norris, Marissa Jackson-So, and Allison Tate.
So first, I just want to thank Alyssa for the wonderful introduction and Dean Perdue for the wonderful introduction. We're so excited to see so many people here. It's great. God, we could do anything we wanted for an hour. We've got a captive audience. It's fantastic. We're not going to do that, though. We're going to talk about LPE, and we are going to address the questions that Alyssa gave us. We're actually going to do it in two parts. We're going to talk, first of all, about sort of what LPE is to us, and how we see LPE and how we define it and how it interacts with our work. And then we will move on and talk about extraction and how we see modes of extraction in our various fields, how we understand the mechanisms of extraction to work, and what does that actually look like on the ground? Like, where do we see money going? Where do we see the resource extraction? What does it actually look like? So we were going to start with Professor Norris. I don't know why we have the man first, but we're doing it. We're just doing it.
Their idea, not mine.
We're doing it. So I'll keep a little bit of time, and we'll do about 5 minutes each, and then we'll move on.
Great. So I thought I'd tee us off by talking a little bit about what law and political economy is. And there's a really active conversation about that right now, about sort of what this move is. And I think you sort of see the rise of it in the wake of the 2008 financial crisis, in the wake of recognition that there's mounting economic inequality, that corporate power is consolidating in some ways. And so it has roots in older ways of thinking about law and the economy and democracy, and studying markets as sites of power, and making it clear that law ought to figure in our understanding of how economic power works and is consolidated. So it's really focusing on how economic power both shapes and is shaped by law, and as Dean Perdue said, not viewing legal relationships and rules only through the lens of neutrality, but centering questions of power, subordination, and democratic participation and vitality. And so in that regard, I thought I'd talk just for a minute about sort of the older roots to which law and political economy returns. So as all of you learned who went to law school in 1L Con Law, there was a battle over the rise of the regulatory state after the Industrial Revolution and the Great Depression. And there was a sort of what's been called a classical liberal way of thinking about markets and the economy, right? Which were that markets worked well through competition and self-regulation, and the role of government was sort of to step back, right? So this was the battle over laissez-faire, that the notion was that law and the government should step back and sort of let the economy run on its own. And some of the roots of law and political economy come from institutionalist economic thinkers and legal thinkers who said, hold on, we need to actually step back and look at markets as sites of power and potentially subordination, right? We need to look at the precarity of work and workers, for example, right, in markets. And by doing so, we can see how law actually shapes market power. And if that's the case, if law and the government and the state are always implicated in how the economy works and how power works in it, then that sort of takes power out of laissez-fairist arguments that we should keep the government out of it, right? Because law and the state are always implicated in what happens in the economy. And these folks sort of were the intellectual architects of the New Deal legal order, where we recognize a more affirmative role for government in shaping the norms and values that guide the workplace and the marketplace. So you can think of the rise of the Fair Labor Standards Act, the Social Security Act. You can think of the Sherman Antitrust Act, right? And all of these statutes that saw a role for law and the state in mediating and intermediating market relationships, right? But the interesting thing is once the New Deal order was won, then there was a shift with the rise of sort of modern economics and what we might think of as modern law and economics, again, returning to questions of neutrality, returning to the notion that what ought to happen is that the government ought to stay out of markets. So if you think of the Reagan Revolution, right, on the heels of that, and you think of what's been called the rise of the neoliberal legal order, where once again, the notion was that what the government ought to do is stay out of market relationships and let the economic engine and innovation soar, right? And there was that transition again. And that transition came to shape legal thought and legal thinking. So as Alyssa so brilliantly said, right, there was this notion that, in public law fields, we really didn't talk about the economy that much, right? You could talk a little bit in constitutional law about the economy. You didn't really talk about economic power very much. And in private law fields like antitrust and others, it really was about efficiency, right? When I went to law school, I learned the Coase theorem, right? Mm-hmm. But I didn't learn about anti-subordination or theories of equality. And so I think we can see LPE as a counter response to that, right? So it's sort of as the 2008 financial crisis hit, right, as there was a mounting dialogue about economic inequality, right, as we've seen the great consolidation of industries where there are, maybe 2 or 3 corporate players, we then recognized that there needed to be a shift in legal scholarship to recentering these questions of equality, power, and the inevitable role of the state and law in shaping market relations. So I will stop there.
Thank you. Erin?
All right. Good morning, everyone. It's good to see so many faces. So I want to talk a little bit. My area, that's loud. I teach criminal law-related classes. I am a former appellate public defender, and so I write in the area of criminal law and procedure. And so I'm going to spend a few minutes talking about the political economy of the carceral state, and really thinking about how an LPE lens complicates traditional understandings of or assumptions about criminal law and punishment. Specifically, accepting the invitation that LPE provides to scrutinize the seeming neutrality and objectivity of our current legal system and structures with an eye towards how power operates, resulting in a system at which some benefit at the expense of many. Right? So we might think, and many might teach, criminal law as a series of rules that we as a society have come up with to identify what behaviors are not allowed and to provide punitive consequences for those who violate those laws. Right? In criminal procedure, through this traditional lens, are the constitutionally required processes we follow to make sure that convictions are achieved and punishment is imposed in fair and a just manner, and only against those who are actually guilty. LPE helps us see that that's not so simple. Political and economic forces shape both what behaviors are designated as crimes and against whom those laws will be enforced. So, in other words, who becomes criminal. The history of punishment practices in the United States provides a stark example of these claims. Incarceration as a punishment practice gained prominence as the practice of chattel slavery ended. At this time, we see the creation of black codes, which criminalized innocuous actions like standing or walking and applied only to black people. Meanwhile, we see the state increasingly turn to incarceration as a form of punishment for these new crimes, which then enables practices like convict leasing, whereby people whose behaviors have now become criminal under these new codes become a source of labor for an industrializing nation. A more contemporary example is the prison building boom of the 1970s and 1980s. Through a traditional lens, prisons are built and are necessary because crime is high and we need them to keep people safe, keep the public safe, keep the free public safe. In her book, The Golden Gulag, Ruth Wilson Gilmore provides a different account. In that book, she identifies the roots of the prison building project in California in the 1980s as being established and starting from the collapse of the golden age of capitalism in the 1960s. There she shows how revolutionary social movements and a changing economy created surpluses of land, capital, labor, and state capacity surpluses that could be addressed by the building of prisons. Through this lens, Gilmore shows prisons become legible as, quote, partial geographical solutions to political economic crises organized by the state, which is itself in crisis. And even more recent example is the building of prisons in Appalachia, literally on the sites of mountains that have been raised after coal has been extracted and the land can't be used anymore, right? Taking a more literal view of the economics of the criminal system, the US spends approximately $300 billion annually to police and incarcerate people. About half of that, $143 billion, is for policing, about $88 billion for operating punishment systems. The traditional view would be that this is the amount of money that's simply necessary to keep the public safe. But we know incarceration causes harm, and that the way policing and incarceration are justified in the public discourse ignores the vast physical and emotional harms and terror and trauma that these systems inflict on the people they target. We also see that incarceration has at best marginal impact on rates of crime committed beyond prison walls, and that they leave many people in prison or jail to be traumatized and even in an even more economically vulnerable position when they ultimately leave. Meanwhile, these vast expenditures of public money, of our money, to operate this system reflect a choice by those with the political and economic capital to invest in criminalization instead of education, public welfare, public health. And this choice reveals a particular ideology based in racial capitalism to protect and recreate existing power structures through policing and punishment. So some would say that all of this shows that the system is broken. The analytical tools of LPE help us see, in the words of Paul Butler, that perhaps the system is working the way it's supposed to.
colleagues. If I had 15 minutes, I might talk about our Washington v. Davis problem, right, and the way that constitutional law has actually directly impacted the economy. But I actually only have 5, maybe 4.5 now. So I'm actually just going to talk very briefly about economies of extraction and the necropolitical state. I think and write a lot about necropolitics. So let me just sort of define what necropolitics are in brief for you. Sort of as described by philosophers and political theorists such as Akila Membe and others, necropolitics are sort of when you are governed under the threat of death, right? So you can think of it as sort of surveillance and policing, but you can also think of it as having to sort of, right, eat what you kill and engage in survival labor or subject yourself to work conditions that are not ideal, because if you don't, you will starve to death, right? So when I'm thinking about the necropolitical state, I'm thinking about sort of, right, the like force of the state, but also the quiet, sort of subtle, unspoken force of the state that says, if you don't work, we will let you die, right? So there's laissez-faire, which means, let it sort of happen. But I'm thinking about it as laissez-tuer, let them kill you, right? And so just breaking it down into sort of 3 types of necropolitical states. And if you take like state power with me or anything like that, you'll hear about this a lot, right? There's the authoritarian state, right? And we all sort of have ideas in our head about what the authoritarian state is, right? Sort of very central government, and where the citizens or the populace sort of work without sort of any expectation of real compensation and the complete extraction that goes to the benefit of the state, right? And then there's the apartheid state, right? So the apartheid state, there's democracy for some, right? There's freedom of contract for some. And then there's an underbelly, right, of that state where people are the source of extraction, and the capital that they generate goes to the people who are on sort of the bright and sunny side of the apartheid, right? The people who have the rights and the people who are part of the social contract of the apartheid state. And then there is sort of the market democracy, which is what we kind of have. Right? And there's the idea that in the market democracy, then everybody's sort of free to make their own choices. Everybody has equal bargaining power to make contracts and procure property and sort of make out sort of the life that they are either smart enough or strong enough to make out for themselves. And as you've already heard, there's this idea that the government, right, is supposed to sort of sit back and let that happen. Right? And so, for example, in a case like Shelley v. Kramer, right, which sort of outlawed housing discrimination, restrictive covenants, the idea was we don't want to restrict private discrimination, it's just that we, the government, can't enforce it, right? So they never said racial discrimination in housing is bad. They just said when it comes to us, we can't enforce it. And so in a trickle-down law way, that means you may as well not waste your time, right, engaging in restrictive covenant and sort of structured racial discrimination housing schemes, because by the time you're sued and comes to us, we're not gonna be able to enforce that. The problem is that even in the market democracy, right, when the state, right, in 1976, with Washington v. Davis, sort of said, we're actually going to just really let the market sort of determine who gets jobs and who's not. We're not going to try anymore to sort of make sure that communities that are disproportionately excluded and removed from the ability to get jobs and make money and create wealth for themselves and their communities. We're not doing that anymore, right? Once that happened, once the state removed its protective hand, right, you now see that while the right to contract exists formally, while the right to procure property exists formally, the inequality in bargaining power increases such that people are required to take any job they can get under any conditions they can get, right? And a lot of this discrimination that happens, I know, I'm coming. A lot of this discrimination that happens is still happening. It's just sort of under the radar of the government. And so at some point, the market democracy actually starts to resemble the apartheid state. And even worse, now in Silicon Valley, you've got guys like Peter Thiel and Curtis Yarvin who have insane amounts of money actually dreaming of an authoritarian state, what they call the corporate dictatorship, through which people who are less valuable, who don't work as hard as they would like, who don't make as much money, they are dreaming of making, turning them into biodiesel fuel for municipal buses. And it's easy to cast them as fringe, except that they've got another friend, right? There's a trio of them. And one of those guys, one of their good friends is J.D. Vance. And Peter Thiel sunk a lot of money into his political ambitions. So at what point does our market democracy move past a sort of de facto apartheid state into an authoritarian state? And I don't have the answers to that. I just wanted to leave it with you.
You're like, I'll leave you there. Okay, thank you. So I'll close us out for this round of questions, or this question about what LP is in terms of our own areas. So as many of you know, having taken my class, I write about families, and I write about money, and I write about wealth inequality. And as Professor Norris said, like LP is in a lot of ways an old story made new. There's a historical context here, and certainly what we're living in now, right, is a re-upping, right, of what people have called, people think of as Gilded Age, or we're in a sort of a second Gilded Age where the levels of wealth inequality are enormous. They are that's at levels that they haven't been for a century. And so LP helps us to think about how we got there, which is again a historically contextualized movement starting in the 70s, starting with sort of this idea of prioritizing markets, starting with like the Reagan Revolution, which actually was just a tax revolution. If you look back at Reagan's speeches, he talks the whole time about taxation and how he's going to liberate the country from taxation, just like the founding fathers did, right? It's a tax revolution. So a lot of it is trying to understand how we got to this sort of second Gilded Age, and how processes were put in place, how certain market norms were embedded, and certain ideas and systems of collective repair were decimated. So understanding that push, right? And so when we've talked about LP so far, I've heard 4 people mention constitutional law. I've heard some antitrust. I've heard criminal law. But what I haven't heard is family law, or people talking about families. And I think this is one of the things that actually is LP has work to do in understanding how laws around families and home space fits into LP. And this is something that we'll hear about when we hear from Professor Zhang, who writes about this and tells us great things. I just read her most recent article in the BU Law Review, which was fantastic, and she will help us think about that. But it's something that LPE needs to think about more in terms of like these type of extractive relationships, not just in what we consider to be public workplaces or public spaces or through public law, but also in families. And I'll talk about that more when we get to the extraction part of things. But we need to think about these private relationships and not re-embed notions that the family is somehow exceptional and accepted from the, exempted from market norms or market relationships. So I think this is my sort of prompt to and challenge to LP and LP people who are writing in it to think about, again, how this works within the family. And we can think about it in a lot of different ways, at least in my area, right? We can think about it through family law and different rules that govern the family, just even in terms of, even in terms of marital property and distribution. We can think about it, my favorite thing to think about, trust law liberalization, right? And the ways in which we allow people to both accumulate and protect money. As I mentioned, we can talk about it in terms of tax law. Melinda Cooper just wrote a wonderful new book where she basically talks about the tax revolution and estate law, depreciation schedules, the change in marginal rates, and how this effectuated new, again, these new inequalities and these new forms of sort of bifurcated, right, a bifurcated society, where you have the laissez-faire and laissez-mourir, right, where you have the two polar ends. So that's what I think is the interesting part about LP in sort of thinking about families and money. And again, it's an area where I'm glad that there's lots of new work being done that's really exciting. And it's an area where I think there's lots of space to think about, again, the relationship between power and families. And again, we'll talk more about extraction, but it's a site, certainly the family is a site of both accumulation and extraction. It's a site of violence, and it's a site where we could imagine repair. So I will leave it there, and we will move on. Look at that. I'm even early.
You're right on time.
I was right on time. Thank you.
Well, that my time.
So the next question, so we sort of have addressed what LP means to us, what it means to our work, our research, our modes of scholarly production. And then the real question is sort of how does that work? Like, what does it look like? And Professor Collins mentioned, right, sort of like funding of the Carceral State, and we have some sort of hints and previews about what extraction looks like in various fields, but we'd like to now sort of take a little more time to talk in more specifics about what it looks like to see, or what it's like to see extraction. How do you see it, right? We can talk about it, we can name it, but how do you actually visualize it, and what does it look like? So we will go in a different order. We're not going to start with you again.
Thank you. Thank you.
Would you like to start?
Sure.
Okay. Then we'll go. Okay.
Okay. What am I talking about?
Extraction. What does it look like?
What does it look
What
like?
does it look like? How do you see it? How do you recognize it? You're walking down the street and you're like, how do I see extraction?
How do we see extraction? It looks like, a lot of people who are working sort of hourly wages. They are often sort of our hardest workers. They are often doing work that we, as the rest of the society, can't sort of deal without, right? Like what happens when nobody's working at CVS? What happens when nobody's working at the grocery store? What happens when, right, the orderlies are not in the hospital, or the home care and sort of daycare workers are not available, right? Your life sort of falls apart. But those people are grossly underpaid. In many places, those people cannot expect a living wage. And the response to their sort of financial misery is, you should have gotten a better job, right? You should have worked harder. You should have, you're getting what your labor deserves. And yet that labor is literally keeping the rest of the economy going. Like, we are able to come to work, right, and in the professional sector because those people are literally propping us up. They're cleaning our homes, they're watching our children. You're right, they're stocking the shelves of the grocery store. And that is the most everyday sort of version of extraction. It happens in the light of day, it happens in our faces, but we don't often think about it. They make enormous amounts of money. So I know that at even sort of your smallest Whole Foods market, for example, and there's many issues with Whole Foods market, just in use of prison labor and all kinds of things, but let's just keep it cute and think about your everyday sort of purchase of $7.99 per dozen quail eggs, right?
I think they've gone up to $8.99.
Are they up to $8.99, right, for the quail eggs? Okay, so a Whole Foods market can make $100,000 in 4 minutes, right? That's an extreme amount of money, right? Think of how much money a single store is making over the course of a full day. But your average worker, including your supervisory workers, are making about $25 an hour. That's what extraction looks like to me. And then when you look at who those workers are, immigrants, people of color, queer and trans people, right? Largely because they are locked out of other aspects of the economy because they have been sort of filtered out of the opportunities for more lucrative positions. And then you see what extraction, right, and then racialized and otherwise oppressive extraction look like.
Oh, sure, I can go. All right, got to time myself. Okay, so I had more notes about extraction because I was like, there's so many ways to see it, and it's such a, making what is sometimes invisible visible is sort of the fun part of this. So I was thinking, before we had like really entrenched carceral systems, before we had Whole Foods, right? Sort of the original site of extraction is actually the home, right? The home is sort of like ground zero of all extraction. So I think I'm so happy we're talking about it, and that it's something that we're putting on the radar, right? So the home, again, like I think probably there are no footnotes to this statement, but again, the original site of extraction, and it's mostly because of the marriage relationship, right? The marital relationship, and it's the cover for a lot of different forms of legal violence, right? I mean, I'll just leave aside physical violence for the moment, but it's definitely the cover for a lot of economic violence. It allows for wage theft, it allows for resource extraction, and it's deeply gender-based and it's deeply economically violent. So this is again, the sort of the stage one of where this happens, right? Through specialization of labor in the home and the extraction, again, of work and labor, reproductive labor, home labor, all kinds of labor in the home. This is what extraction looks like, right? Raising children and not being paid for it, right? Doing work, doing people's laundry, making meals, doing all of these things and not being paid is extraction. So, feminist economists and other wonderful scholars have talked about the home as a site of social reproduction, and social reproduction is, right, extraction. And we might think this is, kind of an old version of what the home looks like, but I would contend that it's still going on today, and it's still deeply gendered, but it's not just women, it's all subjects who are feminized within the home, and you still have the gendered patterns that are happening. And it's interesting, so Maria Demise, who's a sociologist, she has a term for this. She talks about, it's always hard to say, housewifeization. That's her term for what happens, and it's actually like sort of the primary pattern of how things go for. She talks about colonization and housewifeization and the relationship between the two. And it's really basically, right, it's a process of oppressing certain populations in the home, right, traditionally women or feminized people. It's stealing labor, right? It's creating cheap labor through reproduction, right, and unpaid. It's producing cheap workers, and it's also creating a market at the same time for the consumer goods. So she's like, this is your template, is what's happening in the home. And so she talks about the housewifeization of other areas. So I think that's an interesting way of thinking about it. So that's family law. There we go, move on. One way to think about extraction. Another way is to think about not just the family money and who's gaining and who's being harmed economically within the home and the household economy, right? That's sort of like thinking about inequality within the home and within a family. There's then thinking about the transfer of money, right, from one generation to the other, and that really fosters inequality between families as opposed to within the family, right? You have gender-based inequality within families, and then you have economic-based inequality often between families, and this is all, there's racial patterns, there's racialization, there's, all of the economics of marginalization and minoritization that we are thinking about collectively. But in this situation, I just wanted to sort of point out that while family law rules basically enable, again, the sort of social reproduction, wealth transfer rules embed the right of some to transfer money more easily and with less friction than others, and they enable and protect, some families to pass down wealth, right? And as Maria Demise would call it, big European men, to pass down wealth, while others pass down financial precarity and need, right? It becomes a cyclical phenomenon. So this is, in trust and estates law, this is thinking about which families are allowed to accumulate and preserve, the channels that they're allowed to use, like what mechanisms are available. And usually the mechanisms that are available are based on, the availability is based on your existing or pre-existing wealth. And these are also extractive. So I'll just finish by saying, so on the accumulation side, wealth accumulation, extraction happens when high wealth families and individuals do things like buy the debt of the poor, invest in debt, invest in predatory lending companies. There are more indirect ways, but those are some really obvious and direct ways in which extraction's happening. Profit from investments in the carceral state, things like that, that's extraction. And then taking that money and preserving it through mechanisms that are available only to high wealth people, through corporate entities, through asset protection trusts, through things like that that allow creditor protection, right? Protection from creditors in a way that no one else would have, right? low-income people who are in the carceral system cannot escape fees and fines. They can't escape creditors. People with an asset protection trust are immune to creditors. So there's a protection element to it also. So I'll end there because my time is up, but there's a lot of extraction.
I'll pick up on the theme of there's a lot of extraction. So I'm teaching a new seminar this semester called Punishment Law, and for the next, I designed the syllabus over the summer and over last semester, and we're spending the next two classes on the topic of economics and economies of punishment. As I was designing this syllabus, I think it could be an entire class, right? I limited it to 2 classes. There's a lot more I would like to talk about in that class, but this is giving me an opportunity to visit some of those texts and think about it. So criminal punishment in the form of incarceration very literally extracts people, right? It's a practice of extraction, extracting whole people from their communities, their families, their support systems, their jobs, their neighborhoods, their educational institutions, their places of worship. And that act of extraction has devastating impacts on those people and on that person's ability to support themselves, their loved ones, their respective networks, both during and after a term of incarceration. While one is incarcerated, it's impossible to have employment other than the required prison labor. And the fact of conviction itself then makes it harder to achieve stable and well-paying employment afterwards. And it's even more difficult if someone has been out of the labor force because of incarceration. This economic disadvantage has an intergenerational ripple effect that builds on pre-existing structures of racial, gender, and economic inequality. Meanwhile, the very process of being charged and perhaps convicted imposes very direct economic costs. Criminally charged people regularly pay for the process of their prosecution and their incarceration, if that is their method of punishment. So one estimate was that the average court cost for someone who's arrested is more than $13,000. And that's from almost 10 years ago. I'm sure that the average is much larger now. But beyond paying for fees for services people don't choose, right? Like paying for court costs, paying for public defenders, paying for blood tests if relevant, paying for DNA tests if relevant, right? There's also fines that are added as another form of punishment. And failure to pay these fees and fines extracts different kinds of costs, including the inability to vote. So we've seen, thankfully, a movement to give people who have been convicted of felonies the ability to be re-enfranchised. But at least 30 states condition reinstatement of voting rights upon payment of legal debt, right? This practice of the lingering debt of carceral practices has been called a modern poll tax. And even seemingly more humane punishment practices that leave people outside of incarceratory systems contribute to extraction. People on electronic monitoring, for example, pay exorbitant fees for the monitoring equipment, or regularly scheduled drug tests. And there's this whole burgeoning critique of what's been called the treatment industrial complex, this system that has emerged to supposedly supplant, for some, practices of incarceration, but that extracts its own costs. Meanwhile, if we talk about the accumulation side of things, many people benefit economically from these carceral extraction processes. We often hear a lot about private prisons, organizations like Geo Group and CoreCivic, which run for-profit places of incarceration. That's actually a relatively small slice of the carceral pie, except if we're talking about using places of detention for immigration practices. The private prison groups are very active in that space. Technically, immigration detention is not punishment, so it's not directly or literally part of the carceral system. It is part of the carceral web. But if we just think about what happens when someone is incarcerated, right, we're removing them to places of incarceration. It means they can't access goods, services on their own. They can't access life-sustaining services like access to phone calls and technology to stay in touch with their loved ones. They can't, on their own, acquire healthful food or meaningful health care. Through the privatization processes that have been enabled by neoliberalism, unsurprisingly, for-profit companies have quickly stepped in to provide these services at a very high cost, right? Extracting wealth from folks while they're incarcerated. We can talk about market politics, right? There's no market, there's no choice, there's only one service provider, right? And so I think on the broader scale, I hinted at this in my preliminary remarks, we can also see connections between different modes of extraction in carceral systems, right? Environmental extraction in Appalachia, once resources have been mined, land is no longer usable, right? We can fill in the economies that are struggling. We can use that land for places like prisons, right? So I think there's connections between all of these different systems of extraction, and my time is up.
All right, so I'll try to be quick because I'm what stands between you and Q&A.
You're never quick.
Yeah, no, I say try. It's going to be an uphill battle. So I'm a sort of funny scholar in that I both write about and think about civil procedure in courts and labor and employment. So I thought I'd talk a little bit about how courts, particularly in the civil context, facilitate extraction, and then I'll say a little bit about labor. But we're gonna hear a lot of great things about labor later. So, in terms of I think we can think of it in two ways. One, in terms of courts facilitating extraction, or the other way is courts thwarting remedying extraction, right? So when I think of courts facilitating extraction, I think of the burgeoning literature right now on how the procedural rules, largely in state court, governing debt collection and housing and eviction proceedings, inure to the benefit of powerful institutional defendants. I see that we might hear about that a little bit later too. Courts are rubber stamping. So the largest defendants in state court by far are debt collection plaintiffs, right? So they're debt collection companies that are plaintiffs. In state courts, over 98% of the cases are brought, and the largest group of plaintiffs are debt collection companies that buy debt from the original debt holder, often for pennies in the dollar, and bring these actions. And they're winning largely through default judgments. What I teach in civil procedure about the federal rules and default is often not what's going on in state court. So civil procedure colleague Pamela Bookman has a new University of Pennsylvania Law Review article on this, on how states have relaxed default procedures such that folks who are having their wages garnished and the like because of debt aren't getting adequate notice, right? And then suddenly they have a default judgment and garnishment because they owed some debt. And these debt collection companies often have very little information about the debt. So we can think about how in that context, civil rules are being relaxed in ways that facilitate debt holders and that facilitate landlords and mortgage companies in without great process, right? Taking economic resources from others. On the other side, extraction happens in the economy, right? Wage theft happens. Folks aren't paid overtime. Antitrust law you can think of as dealing with a form of extraction. An illegal monopoly, right, that overcharges us, right, we might say is extracting. Employment discrimination law we might think of as a form of extraction. You're being withheld a promotion or a job, right, on the basis of your membership in a protected group, right? So that economic resource is going to someone else in a legally impermissible role. And on that side, we see the flip happening. Rather than facilitating the remedy of extraction, we see the civil justice system thwarting folks from using courts to remedy the extraction that they faced in the economy. So in civil procedure, I just taught, they must have class. I just saw a bunch of my civil procedure students leave. Once I said the word, talked about we just talked about the heightening of pleading barriers, right? We can think of the way that it's harder for plaintiffs to gain standing. We can think of the increased use of summary judgment, right? So there's a book by Sean Farhang and Steve Burbank, which I recommend to people, called Rights and Retrenchment, and it talks about how the federal courts have reinterpreted long-standing procedural rules to stop or to thwart or to make it more difficult for plaintiffs to bring private enforcement causes of action, and a lot of those causes of action are there to remedy extraction. So, I've almost used the whole 5 minutes. What a shocker. So again, we see the facilitating of extraction through courts on one side, and then the thwarting of the remedy of extraction on the other. I'll just say really quickly in my 19 seconds left that collective action is at the center of this, right? So it's harder for folks to bring class actions now and to exercise countervailing power when there's large-scale extraction, but also, as we'll talk about in the labor context too, it's more difficult for folks to form labor unions and to bring the types of proceedings and to exercise type of collective power that might actually augment their power, right, and then stymie extraction at the root. So that was a very quick 5 minutes. I thought I'd go for 2, but those words just unfurl themselves, don't they? They just...
Went for 2, could have gone for 10.
That's true.
That's wonderful. Well, thank you. So we have about 15 minutes left, so we can have questions from the audience. We welcome any thoughts, any questions. People want to... Yeah.
Thank you guys for that discussion. My question is for Professor Jackson but is also welcome to any comments. I know a lot of your work talks about visual culture, and I'm curious, when you have these images that are being used of those who have been exploited, when does that then become further exploiting them? Mm-hmm. You know, these situations after hurricanes, when you see these images of victims who are already suffering under the government, how do you toe the line of trying to bring awareness to the economic inequalities, or when do you become part of the problem of extraction?
That's a really great question. I will just preface, I have no competency in the areas of like intellectual property or copyright or anything like that. But you're hitting on something that's very, very important, which is sort of the ways in which, particularly in the light of, like, in the aftermath of disasters or spectacular catastrophes, that there is it can become a spectacle itself, and can contribute to existing patterns of subordination and things of that nature. So I think I've been thinking a lot recently about sort of like the aftermath of Hurricane Katrina. And while we definitely relied on visual culture to actually sort of make the suffering of people who are in the Superdome and people, right, sort of trying to cross the bridges out of New Orleans into, right, suburbs, predominantly white suburbs, and then the police shooting over their heads, that made the suffering and the injustice sort of palpable and real, and that was very important. And this might not be responding directly to your question, but I'm going to sort of go for it anyway, which is because of existing biases, a lot of that visual culture was used to support, right, other narratives, right? There were a lot of narratives about folks looting when they were actually, when the system, sort of society had already broken down, and so it's like, if you need the diapers for your baby or the bread to eat, right? There was no reason to characterize that as criminal activity, but you were relying on the skin color and the appearances of the people engaging in that activity and using it as an excuse to sort of subject them, right, potentially to either the carceral system or to the actual sort of brutal and fatal force of the state, right, through the police officers that were there. And so in some ways, I wouldn't blame the visual culture itself. It's sort of how that's interacting with existing systems of oppression, with existing rhetorics of oppression, with existing discourses, right, of white supremacy and black subpersonhood, brown subhumanity, the existing exclusion of those communities from deservingness, right? And using that as a way to further exclude and subject them to the potential and the power of death, even at their most miserable. Thank you.
I apologize, I apologize. This is also for Professor Jackson. So we were talking about kind of what I have heard very recently dubbed essential workers and extraction in the relationship with workers whose labor is maybe societally looked on as less valuable but is essential to the running of society. It made me immediately think of COVID-19 and the pandemic, and so I was curious if you've heard how has that highlighted the conversation, or has the conversation shifted at all, looking at what our relationship has been to essential work and exploitation and extraction in that space?
Yeah, absolutely. So when the pandemic kicked off, I was living in New York City, and I will sort of like stop hiding the ball. The reason why I know so much about Whole Foods, my husband actually works for Whole Foods and was sort of dubbed an essential worker at the time. And so he's worked for Whole Foods sort of all over the country. And I sort of watched his trajectory sort of up through the ranks of the company, but sort of like how some certain employment conditions do not change or improve. But going back to 2020, living in New York City when that was happening. So there was this whole drama of when you would leave your house to go to your essential job, people would clap for you, right? At 7 o'clock, everybody in New York City would clap as you would go to your job. And it was sort of like, oh, our heroes are saving us and keeping us going. Okay, so my husband is going to his job, but because he is a tall, right, skinny, African, right, presumably Muslim immigrant, right, he would be stopped on the way to work because there was also a curfew happening, right? So there was a lot going on. He was commanded to go to work. So I had the luxury of staying home and being safe. He was commanded to go to work, and one of the guys that he was supervising clocked in sort of before or after him one day, went home, and promptly died of COVID, right? And so just this real exposure that all the essential workers had to sort of the potential of death. He was forced to go to work anyway, right? But in being forced to go to work, he was facing cops with billy clubs and things like that, asking him or demanding, right, that he prove that he was not breaking curfew, right? And so I think that was something that I really started to think about. What does it mean, right, to be an essential worker? There are the essential workers that are leaving their house in scrubs and are getting the applauses, but there are so many other essential workers who are required to come to work but couldn't necessarily rely on immunity or exemption from sort of brutality. So we actually decided, at one point in June when the protests got really huge, he had to go to work, and there were, so police helicopters and everything, and a lot of my neighbors were sort of beaten and things like that, and sort of kettled on this like bridge between the Bronx and Manhattan, and we just moved. We just picked up and moved. We were very lucky that we could do that. Most people can't just pick up and move because it's extremely expensive. But I would say that 5 years later, I think we're still trying to recover from the cost of just picking up and moving with our kids. And so I think that's another way that sort of extraction happens with essential workers.
I'm going to pick up on that for a second, too, just because I want to recommend to folks an essay by Vina Dubal called Essentially Dispossessed, which is on this very topic. And Professor Dubal writes about app-deployed drivers, so Uber or Uber Eats or DoorDash in California during COVID-19. And the struggles that they had because they were called essential workers. But she tells the story of one worker named Hope who had medically fragile, complex conditions, but who didn't have health insurance and was an essential worker and indeed needed to work because what was going on was there was a struggle in California over whether or not these folks could get the type of COVID pandemic aid because they weren't formal employees and the like during COVID-19. So the story is Hope's sort of medical struggle, her continued work as an essential worker, and the very long time it took for them to get some of the pandemic aid because they weren't classified as employees that other folks did. So again, it's called Essentially Dispossessed, and it's exactly on this topic.
So this question is for Professor Tate because it relates kind of to extraction within the family model. But anyone feel free to jump in. I wanted to know your thoughts specifically and kind of what the scholarship is saying, if anything, around the idea of extraction specifically from birthing bodies as it dovetails with the repeal and lack of access to abortion?
Yeah, I mean, that's a great question, right? I mean, because so much of this is reproductive labor that we're asking people to do. At the same time, we're regulating reproductive labor in ways that are, right, regulating bodies in ways that we have done before, but we haven't done recently. So I think it's interesting, right? You think of all of the reproductive labor being done within the home, and I think what's important to think about, right, is the type of reproductive labor that's been normalized, and then all of the other types of reproductive labor that are being penalized, right, and banned, right, in terms of reproductive labor. So you think of there's extraction happening in all of them, right, but there's extraction, even in something that might be conventionally acceptable as a type of reproductive labor, there's extraction happening. But then there are other forms of reproductive labor that have been through narrative and through other forms of sort of like cultural processes and political discourse, been turned into unacceptable forms of reproductive labor and been not only extracted, right, there's extraction, but it turns from just the economic extraction into like the violent extraction, right? It turns into the actual like regulation and harm to people's bodies and lives, right? And so I think, and it's interesting, there's always been this sort of boundary between what's acceptable reproductive labor and what's unacceptable reproductive labor, and that's what we're fighting over right now, right? It's like if you look at what's on the boundaries, right, if you look at something like IVF, right, that's sort of like on the boundary of where we're fighting and whether that fits in as acceptable reproductive labor or unacceptable reproductive labor. And the fact that we're even fighting over IVF shows you like the shrinking, right, of the scope of what is actually like acceptable reproductive labor. But it's all extractive, and it just depends, again, it's moving from extractive economic labor to not just extractive, but also violent. And then I think if you look at the economies around these various like forms of reproduction, there's also like extractive patterns happening there in terms of who's profiting from people's reproductive journeys. There's also this is sort of brings in ideas about medicalization and also brings in, a lot of sort of different industries and, sort of corporate interests into who's profiting from women and people who bear children, right, from their bodies. But I guess what I would just say is like the huge increase, which I think we all know of, the regulation and discipline, right, of the bodies and what's become acceptable. What's become acceptable is so small that there's just much more harm to be had.
Can I also just jump in for like 30
Yeah.
seconds about reproduction and extraction? So, and when we talk about this in every year in State Power too, this whole, we talked, Aubrey, you'll remember this, the conversation about the trad wife, right? This sort of like push to get people to go back and go on their farms and drink raw milk and have tons and tons of babies. And the sort of the racial discourse that's been sort of implicit but also explicit in that, this idea of racial replacement theory and needing to have more white babies, more Viking babies, more babies, children of the corn. You'd have these pictures of the family where everybody sort of looked like children of the corn, and then there's these
literally in cornfields.
Literally in cornfields, and then sort of the memes about how this is what America's supposed to look like. And so, sort of undergirding sort of a lot of that Dobbs discourse and even just what led up to Dobbs was this idea that we actually need to be able to extract white babies from white women.
Yeah.
Right? And on the other hand, there was also discourse about how, right, because remember, people forget, the Dobbs was about a clinic in Jackson, Mississippi, where all of the patients were actually black, right? This idea that we also need to be able to continue to extract black babies from black women so that they can continue to serve the labor underclass. I was gonna say, this is the interesting part, right? Because
the shrinking of sort of reproductive opportunities for people goes hand in hand with a really super surcharged increase in repronormativity, right? And then certain types of obviously racialized forms of repronormativity that are, put up on certain, right, that are now in cultural discourse, right? The trad wife thing is fascinating.
Very fascinating.
But yeah, so it's it goes hand in hand, right? Repronormativity and then also reproductive penalty. Yeah.
All right, thank you guys for an amazing panel. We're going to go ahead and transition to our next one.
Hi, everyone. everyone. Sorry, that was loud. We're going to get started on our next presentation. My name is Aubrey Bouchard. My pronouns are she, her, and I am the Law Review's annual survey editor for Volume 59. Today I have the honor of presenting Professor Yiren Zhang. Professor Zhang is an assistant professor of labor and employment law at Cornell University Industrial and Labor Relations School, as well as an associate faculty member at Cornell Law School. She earned her doctorate and Master of Laws degrees from Harvard Law School, and today she teaches classes on labor and employment law, employment discrimination, the law of care work, and gender and the political economy. A published author multiple times over, her research focuses on the governance of care work at the intersection of the often informal labor markets, the welfare state, and the economic household. I am particularly excited for today's presentation, as I am a granddaughter whose grandmother relied on her two at-home caregivers in the final years of her life, both of whom were women of color. So without further ado, Professor Zhang.
Thank you for the introduction, and thank you so much for having me here. And I'm really excited to be here, and especially excited to be presenting after the first panel. I think Professor Tate has really set up the floor for my presentation, which is about the gender and political economy of home care work. So in my research, I'm mostly interested in how law, like the legal system, governs care work, how it conditions care as a commodity, as a form of labor, and as a type of public and social goods, and how much the law's impact on these three dimensions of care are often intertwined and interconnected. And especially, I think, adding on to what Professor Tate has said in the opening panel, I think CARE's takeaway for the law LPE framework is how to center gender, how to center home and family relationship in our understanding of the economy and beyond what is traditionally understood as the market. So when I teach work law, we think of this set of like federal labor regulations, NRA, FLSA, Title VII, and other statutory labor laws that give us statutory rights in the labor market. And when I teach my students about, okay, where's power in this story, I usually use this diagram and every rule we study in the work law casebook both divides between what is public state action and what is the private ordering in the market, but at the same time also distribute power between employers and employees and between capital and labor. But when we think about care work, I think this diagram doesn't really capture what is going on in the story. So instead, I will start with this diagram that with these three institutions, three basic institutions, the family, the market, the state, come together. They are interdependent on each other and complement each other in supplying us with the survival resources that we need in our life, either housing, food, shelter, clothes, or care. I think that is basically true for a lot of things that we depend on, that either it comes from a family member that provides it, from a market, you buy it in the market, or you earn it in labor market, use it to buy it from the commodity market, or the welfare state gives you through the public provision system. But it's especially true of care. If we only think about the market of paid care services, that doesn't quite capture the predominant majority of care that's happening in the care economy. And the state can impact the division of these three institutions in supplying in multiple ways. One of the ways is how much it provides. What are the rules that attach to how it provides it? If we have a smaller welfare state, have a smaller public provision system that you have to rely on the family or on the market to receive certain services. Another way that the state impacts the division among these three institutions in supplying any service or commodities is through regulations, like legal rules impacts whether the labor happens in the family or the market, and we attach different rules to it when we imagine it is part of the the family economy or part of the market. For example, when we transact the labor in the marketplace, we usually apply contract and we have a set of minimum wage, organizing rights, anti-discrimination rights, OSHA rights that kicks in. But when it's happening between the spouses or between parents and children, none of these market rights exist. Instead, there is a legal presumption that that's a form of labor of love, that it doesn't have economic value and shouldn't be regulated under the market rules. So if we think about the care economy and how it spreads across all these institutions, that gives us an entry point to really map where legal rules comes in and how the rules of welfare state, the rules of like the labor market or what we call work law, and the rules of the family really interacts and condition how care work, what the terms and conditions of care work look like. So I will use the example of home care, which is the focus of a lot of my research, to illustrate how this works in today's presentation. I will first introduce a little bit what is home care, then I will give you 3 examples of how the rules of the welfare state interact with work law in both generating and conditioning home care work. And for the last part, since we're also talking about hope, I will also give some observations about what this interaction means for advocacy efforts that is used to improve care work. So you might have heard of home care in this context, that Vice President Kamala Harris has announced that as part of her health care reform package is to expand Medicare coverage of long-term care for elders and individuals with disabilities that are delivered in their own homes. So that's precisely the slice of care economy that my research is about. So when I saw this news, I'm like, okay, great. This is finally you have a project that's hitting the front line of the front page of the New York Times. So when we think about home care in the news, it's very often understood as family struggles. Many families have this experience of having loved ones that they need long-term care, and there's a lot of family sacrifices, family arrangement to enable that. But home care is also a very meaningful slice of the labor market. In fact, it is the fastest growing occupation in the US in the past decade. And in many large cities, home care workers, usually categorized under the name of home health aides or personal care workers, are the largest occupational group. That's certainly true in New York City. So there are many political economy reasons behind this trend of the expanding home care industry. One of it is the aging population. We have more people that have long-term care needs, so we need more people to care for them. Second is that as women's participation in the paid workforce increases, many of them partially withdraw, but not completely withdraw from providing unpaid care to family members, giving rise to the market demands for such labor. The particular reason behind the expansion of home care is also the right to live in the community is an important disability right, and it's also a driving cause for the disability justice movement. It's important for the disability community to have their health care. This is a way to enable them to put health care decisions back into their own hands. And indeed, there is a Supreme Court case in 1999 that find that right to stay in the community when certain conditions hit. And the policy reaction to the decision Olmstead versus LC in 1999 to this disability right to stay in the community is the expansion of Medicaid-funded long-term home care programs, which has now taken over more than half of the long-term care. So more Medicaid money are spent on home care compared to nursing home care. I think as we talk about this slice of the economy, it's always important to think about who is doing it. And this structure is heavily reliant on a disproportionately low-income women of color. And as Medicaid home care programs differ by state, so a lot of the stats and compositions in this field is state by state. I use the number from the New York State that according to PHI's home care workforce report, that 89% of home care workers in New York State are women. 18% of them are white, while 30% of them are black, 32% of them identify as Latinx, 16% of them identify as Asian, and the median age of the workforce is 50, which is significantly older than the median age of the general workforce, which is 38. And 66% of home care workers in New York State were not born as U.S. citizens, so it's a heavily immigrant workforce. And while the median earning of this workforce is only $22,000, which is around the poverty line in the New York State. So if we think about how this economy functions, map it onto this family market state diagram, I think we need to keep in mind that the number we saw is what's happening in the market, and there is a lot and probably more long-term home care that's delivered by unpaid family caregivers than paid care workers. According to the report Caregiving in the U.S. 2020, which was prepared by a group of organizations including the AARP, nationwide in the year of 2019, 16.8% of Americans have provided a significant duration of unpaid care to an adult of age 50 or older. So a lot of us still in the family, and when it is actually indeed happening in the market, it's heavily funded by state funding. In the New York State, again, 83% of paid home care is funded by Medicaid. So when Medicaid is not paying for this form of service, the families either do not have the means or the willingness to pay for it. In other words, the way that care transforms from the family into the market is very structurally integrated with public provision, public funding for this specific type of service. And growing out of that structural factor, how the welfare state functions in service authorization, in service regulation, very structurally conditions what this job looks like. And I will use 3 examples to show you how some specific regulations or techniques in the welfare system transforms or interacts with how the job looks like. And as a junior scholar, I also want to promote my scholarship, so I will put the citation to what I said here. If you want to read more, you can find articles online. So the first example is how the Medicaid service coverage really defines what is paid care work and what the boundary of paid work looks like in this field. I will use an example, a real story of long-term home care to illustrate how this system works. And this is a real story I collected from a fair hearing records from New York's public record system. So Grace is an 82-year-old Medicaid recipient who's diagnosed with a spectrum, a list of symptoms, including Alzheimer's disease. So under the New York law, Medicaid should pay for personal assistance service to enable her to stay outside the nursing home. She lives with her daughter, who works outside the home from 10 a.m. to 8 p.m. every week. Grace hires her niece, which is allowed in the New York system, as her personal assistant. The niece will come every morning when the daughter leaves for work. She will help Grace to get out of bed, to prepares for her meal, encourage her to eat and drink fluids, assist her to take shower, to use bathroom as needed, and in the niece's own words, she does everything on demand when she's there. The niece will also stay with Grace until daughter is home, and when she's staying with her, she's there to make sure that Grace does not leave the stove on, does not lock out family members from the house, or does not wander off the property, which had all happened in the past. And whenever Grace gets up, Denise will walk with her to make sure she doesn't trip. Denise will wait there until the daughter comes home, and the daughter will take care of Grace's nighttime needs, and she will take care of her on weekends. In addition to niece and daughter, Grace also has a grandson, will sometimes bring her to the doctor appointment and sometimes stay with her when niece and daughter are occupied. So the question for the Medicaid system and for work law is that within this care arrangement, which part is work, which part of it should be paid, should be recognized, and should be regulated, and especially which part should be paid and regulated by the Medicaid. So how the law functions. There are two sets of rules that are meaningful in defining this boundary. One is the New York State Medicaid regulations. So there are two sets of rules under the Medicaid system. First is that they use an ADL, IADL-based way to authorize care service. This means assisted daily living needs and instrumental assisted daily living needs. And these are the list of tasks such as bathing, dressing, toileting, transferring, eating, or shopping, transportation, managing finance, managing medication, housekeeping, laundry, and food preparation. So these are the services that Medicaid regulation regards as medically necessary personal care service that's enable individual to live at home, and these are the only service that they can authorize to cover. The second set of rules is where what's presumed in family kicks in. The New York State Medicaid regulation also have this rule that if the patient has voluntary support, usually a family or neighbor or friend who's willing to do any of these tasks without pay, if that's the case, the Medicaid cannot authorize public paid service. So what will function in the ground is that nurse will come in and apply these two rules in their assessment procedures. That's what's happening in the welfare law. What's happening in the work law is that Department of Labor has this regulatory guidebook that has stipulated that in this specific kind of care arrangement where Medicaid home care programs are paying for a family member to be the paid caregiver, whatever is authorized in the Medicaid care plan using the set of regulations on the left are working hours for the purpose of Fair Labor Standards Act. And the labor and time falls outside this service plan. Even if the labor has happened, people have benefited from it, that is a form of natural support in DOL's own language that falls outside the regulatory scope of work law. So these two sets of rules function together in defining this boundary of work law, and I will use some color coding to show how this happens in reality. So the nurse will come in, look at this care arrangement, perform some functional task, and the tasks in red here, getting out of bed, preparing meal, encouraging the patient to eat, assisting her to take shower, or nighttime needs, doctor appointments. These are all medically necessary services that is on the index of assisted daily living. And so in the first step of Medicaid regulation, these are authorizable services. The second step, nurse figure out, okay, which of these tasks can family members do for free? And they found out the last bit that the daughter and the grandson are willing to do some of the tasks voluntarily, and everything in blue now becomes a form of natural support. So what's left in the care arrangement are the tasks in red, and then the nurse use a conversion table that the state have assigned that usually takes certain minutes to get out of bed, certain minutes to prepare for meal, and use that calculation, the state come up with a care plan that is 5 hours of paid service every weekday, and that adds to 25 hours of paid work. And then there is hourly rate around New York area that's $19 an hour, and adding together, Denise get paid $475 a week for what she does for grace. So that's how Medicaid regulations and the operation regulation of the Fair Labor Standards Act generates the job of paid home care work. And in my second example, I will show you how some recent anti-fraud reforms in the Medicaid, on the federal side of Medicaid regulation, actually impact how wages calculated and how wages paid or underpaid in the ground for home care workers. So, because of all these public home care programs are very much structurally integrated with the Medicaid system, and it is very much defined by the theme that's happening in the Medicaid system, which is the prevention of fraud, waste, and abuse. And the specific way that fraud, waste, and abuse is generated as a political problem, what is defined as fraud, how fraud is measured, and how fraud is being prevented is very much conditioned, is very much generated by the political economy of the welfare state. So what is happening in this political economy? First, I think there is a very strong sense of distrust in both the care recipients and the care providers. Because these programs are they basically grew out of Ming's tested program that hires a group of low-income workers who are heavily dependent on public assistance themselves to provide service to another group of low-income elders and individuals with disabilities who live on public assistance, that the Medicaid home care programs really see both groups as potential of fraud, commitment, and the accountability, like what is the goal, what is defining political theme in these structures are about fraud, waste, and abuse, not so much about abuse of the elders, but about abuse of the fiscal integrity. Even when elder abuse becomes a concern, it's usually connected with the fact that somebody is frauding the public payment system. And specifically, so there is a distrust. There is the very narrow definition about accountability. It's less about access, it's less about quality of service, which we can all think of as possible accountability themes if we're defining a public service delivery program, but instead the focus is on fraud. And specifically because the current structure of how this system works is very fragmented. So there is an array of federal, state, local, and public-private stakeholders that is involved in the payment, in the payment and in the delivery service. This is a basic graph of how this works. The federal government pays half of the money, the state pays for the other half, sometimes divided by the local. In the New York system, instead of the state delivering the service, they contract it out to manage the care plan, which are for-profit health care insurances. Then they contract it out to home care agencies who employs care workers to perform care to the recipients. And the home care agencies again go out to find direct caregivers to deliver care. And a result from this heavily fragmented system, from a fraud prevention perspective, is that it's very hard to communicate across these stakeholders beyond written records. So it's very hard from the federal CMS to actually know if care is being delivered in the home, and they don't have the capacity to figure out the substantive delivery of service or the substantive occurrence of fraud. Instead, what they rely on is written records. And the way they detect and they measure and they deter fraud is to conduct audit reporting. And by audit, what they do is come in and review all of the records across these actors, see if it's consistent, and circulatively, they define inconsistency in records as the fraud. As a result of that, if you want to prevent fraud, the policy solution is always to demand for more records, to demand for more exacting, more accurate record keeping as a way to supervise both the care recipients and supervise the care workers in proving that they actually need what they are demanding and they actually performed what they are contracted to provide. And this system has resulted in a specific rule that's called the electronic visit verification system. So the law was in this 21st Century Cures Act of 2016. What it does is that it mandates the furnishing of electronic visit verification system for all Medicaid-funded home care programs, and specifically before the issuance of each payment to the care providers, there need to be an electronic verification record of the patient's eligibility for payment, meaning they are Medicaid eligible, the worker's eligibility for payment, meaning they're properly licensed. The service was and they need to verify the service was included in the service plan that was procedurally correctly authorized, and then the service was actually provided. So this reform has like in the rollout, there was a lot of resistance in the state programs because it's really hard to put in this infrastructure. And it finally, after 7 years, it is taking effect across these programs in 2023. So here is an example of how this EVV system actually looks like on the phone. This is usually a type of software that home care workers need to have on their phone. And these softwares, they basically all require pinning GPS, like throughout the work, to make sure the workers where the care should be, which is inside the patient's home. Some of these EVV softwares require the worker to take a picture of the patient or a video of patient to verify that they're caring for them. Sometimes they will need an audio authorization from the patient, and the worker need to put in everything they've did for that patient on that date. And only when the workers can correctly complete the software input that they will receive the payment for the shift. And if they fail the verification, they usually need to go to the agency to dispute, to go through the procedure to fix it, or they just have to forgo the payment for the day. So despite there are a lot of funding that given to state, given to all kinds of organizations to try to implement it, in my conversation with home care workers and with unions representing home care workers in New York, there are a lot of implementation issues on the ground that sometimes it's hard to like just project that it's so hard for the workforce to carry this out. The first set of issue is very much about technological infrastructure. Many workers do not have the phones that are compatible with the specific software that the agency requires. Some of them don't understand how the software works enough, and a lot of them don't have internet plans that can make sure that they're connected to the system throughout their job. GPS accuracy is a very widely reported problem, and two sets of issues. One is about rural areas, especially in upstate New York, where cell phone tower is scarce. I live in upstate New York. I can testify to that. You do not always have phone connections. That there is very hard, like the GPS ping will just jump back and forth and cause a lot of glitches. The second set of problem is sometimes the GPS that the agency has required is too accurate about home, while the patient might want to go shopping, might want to go around the home, but that can become a red flag in the system. The third set of issues is just about the failure to clock ins. In the system that's before EVV was put in, there's usually a care coordinator by the agency that will confirm with the worker on the phone, okay, whether you're there, whether everything is okay, then you start doing your job. But since everything is moving onto the software, the losing of the personal connection there sometimes cause workers just to forget or unable to clock in properly. And the last set of issues about paid family members, and that's where the system, I think, is just from a design perspective, sometimes just fair to capture the work that's being done, especially when the family member is living with or living around the care recipient. Is that a question?
I'm sorry to distract you. My question is that if you had the niece that comes to work for Grace, the example you gave, you said she comes when the daughter goes to work, that is between 10 and 7 or 8 p.m. But you talked about the countable hours. It's like 5 hours. Why is that? Because that would be a difference of about 5 additional hours.
Okay, so going back to the first example, it is because only some of the tasks that the niece does is medically necessary according to the medical regulation. What else that she's done from the regulator perspective
is a form of natural support that a niece would just do for a relative that Medicaid system, through the regulation, through the clinical authorization, doesn't regard as necessary. And to tie it back to the EVV system, that what the niece will do coming in is coming in at an assigned time, clock in, ping the GPS, then put in hours when they're performing the tasks that was on the authorization plan. So what's happening in the ground is that I think it's pretty pervasive underpayment, even between market paid care workers for the hours they perform. So basically, the structure, what's happening in this shift of technological regulation is to shift the risk of fraud from state overpaying for some service that was not needed or not performed to underpayment to care workers, that they're doing things that is authorized, that is compliant, that they have done, but when they failed the technological compliance, they don't get the payment. So that's the second example of how Medicaid, or how about an anti-fraud reform in the Medicaid system actually impact wage payment, which is the most basic the terms and conditions about a job. In the third example, I will also give you an example how the special status we attach to home as a site that's not workplace, how that has evolved in the minimum wage law, but still there are still holes and exceptions in how we define work and especially paid work. So I think by now this slide should be quite famous or infamous among people who know about U.S. work law, that there is a set of home-based exemptions in the New Deal work law statutes that are basically excluding domestic workers, that domestic workers did not have organizing rights under National Labor Relations Act, that they in the first version of FLSA they're not covered, then they're somewhat covered, but now if you're living, then you're still not covered by overtime. And if it's private household hiring domestic workers, that basically OSHA regulation is waived. Especially meaningful for home care is the so-called companionship exemption in the Fair Labor Standards Act. So in 1974 amendment, which add domestic service worker into the FLSA coverage, that there is a leftover exemption of employees who provide companionship services for individuals who, because of age or infirmity, are unable to care for themselves. And this statutory language is still there in the amendment. But there are some changes in how the DOL interprets it. So for long, the Department of Labor has interpreted this exemption to basically include all home care workers if they're providing senior disability care in homes, including those who are doing a lot of active tasks, such as lifting, such as assisting with toileting and all these heavy tasks, and including all of the home care workers who are actually hired by agencies, not individual household. What happened under the Obama administration is that they reserved the DOL, the Obama's DOL have reversed the regulatory interpretation, and then now the rules is that if active care tasks such as assisting with ADL, IADL exceeds 25% of the work time, it's not regarded as a companionship job. So the good news is that almost all home care workers now are actually covered by FLSA. Since the identity of the worker problem has sort of moved, with now the contention point is about what is working time, and then there is still a set of exemptions that's associated, especially about workers who are like staying at the patient's home for longer than 24 hours. So in the institutional workplace, such as hospital, if there's a nighttime nurse, that the space itself marks the boundary of working time. That a nurse, when they're doing a 12 shifts in the hospital, that 12 hours are all work. Even if she take a nap for an hour, even if there's a bell that didn't ring, that she wasn't moving around and assisting with patients all the time, that's still work. But the same boundary of work is not as solid or robust when it's happening in the home, and instead the DOL has a more delicate table defining what is work time, what is not work time. This is only the first half or first 1/3 of the table that you can visit the DOL website to see how the details work out. On the ground, this results, especially in the New York system, that there is a rule called 13-hour rule for 24-hour shift. You might have seen some worker protest about it in New York City. So basically, these are home care workers who are assigned of 24-hour shifts to care for patients who under Medicaid actually need full-time custodian care, that they cannot be independently, they cannot be left alone in the home. But as long as the Medicaid thinks that they don't need nighttime assistance or too much nighttime assistance, the workers will only be paid for 13 hours of the 24 hours that they are actually inside the patient's home. The rationale is that during the time, the worker will take 1 hour meal breaks, that's 3 meal breaks, and the worker will get 8 hours of sleep time. So under the FLSA's, the federal DOL's interpretation of FLSA, as long as the worker can have 5 consecutive hours of sleep that's uninterrupted, this is FLSA compliant to say that the 8 hours of them is not work. And it's not just the work law, it's also Medicaid compensation rules, because remember 83% of these payments are not from private pockets, but from the Medicaid. And for these group of patients, the Medicaid will only authorize 13 hours of payment. So the employers, the legal employers in this case, which is the agency, they don't have the money to pay for it. So it's not just a market practice, but a state practice. And above that, there is also widespread practices of wage theft, meaning the patients will actually need active care, that some patients need to be turned every 2 hours during the night, but the agency and the Medicaid and the insurance company will still categorize them as 24-hour patients, which results in just a lot of work and a lot of interrupted sleep, which has long-term health conditions. I've talked with multiple workers who worked 24 hours, and especially for those who did it for long, some of the arrangement work out where they actually get sleep during the night. Well, in many cases, they don't actually get sleep. When a patient needs help at nighttime, you're the only person on site, you sort of have to assist them. And so that's the third example, and probably to me is the most brutal example of how the welfare law, especially Medicare regulations, interacts with work law in conditioning care work. I will talk briefly about what it means about advocacy efforts. Because of this structural integration of welfare law and work law, I think it also results in a pretty robust coalition between care workers and care recipients, because they are dependent on the same system, and the care workers' working conditions are tied with seniors, individuals with disabilities, living conditions. But this also has two dimensions of it. First is that there is a broader coalition in a lot of these care work advocacies. You see the home care workers bringing their patients to the Senate, to the House, in advocating for things. But it also means that it needs a broader coalition. Any reforms that meant to change home care, if does not get approval from the patients group, from the senior groups, from the disability group, it's very likely to fail. So you have to come up with a plan that really serves both groups. It also means that both work law, meaning labor regulations, and welfare law, meaning Medicaid regulations or other public service regulations, can be points of intervention. Again, it means that there are more laws that you can change to make home care work better, but also means that you always need to think about both laws, and you need to make sure that you change both so that the changes can actually translate into solid improvement for care workers on the ground. So I have two examples how this work. The first example I've done more research about, and I have a little bit more information. So in New York State, in the awakening of COVID and the COVID pandemic, there was a home care worker shortage, which immediately became a disability rights issue because there were individuals with disabilities at home not having enough home care workers, and they're dying. They're literally dying when a home care worker does not come in. So what has happened is the coalition among disability groups, senior rights groups, labor union, community organizations, family caregivers are grouping together, going to Albany, the capital of New York State, and using the state health care budget legislation session as a platform to set regulatory wage regulations for home care workers, and they were asking for setting the sectoral wage a little bit higher, which can attract workers into the industry to make sure individuals who need the service actually have it. It was a success that they raised the wage, the sectoral wage for home care workers, and not just for unionized workers, but also for a lot of these CDPAP, consumer-directed workers who are not in a union. But at the same time, there's political vulnerability that comes with this kind of advocacy efforts. The budget setting happens every year. It means that every year this becomes a potential point that can come under attack, that everything that rose in 2023 regulation can be reopened and rediscussed again in 2024. And that's indeed what has happened. They've resisted the backlash efforts in 2024, but we don't know the year going forward. So the last example is a little bit more prospective. It's a new regulation coming out of the Federal Center for Medicare and Medicaid Services. It's meant to be part of Biden's Medicaid reform that focus on access, focus on equity, focus on quality of service. It passes a rule that stipulates that at least 80% of Medicaid payments for home and community-based service, which is primarily home care, must spend on direct care worker compensation. So the idea here is to tie labor compensation to quality of care work and to make sure that the money that's passing out from the federal government actually end up in the care workers' pockets, not in the layers of intermediaries in between. I think on paper it has potentials. I think it's in a creative way to think about it, both under the welfare law logic, which to save budget, which is not overspend, but also the work law from the workforce perspective, which is to raise wage. It just passed this spring. It has a 6-year timeline to enforce it. So as a more grounded up social legal scholar, like how it works will always depend on how it works on the ground, but there is potentials, and we will see how the state implements it and whether this regulation can indeed be a rule that raises both the quality of care and the quality of job in this field. So that's the end of my presentation, and I very much look forward to your questions.
There.
Thanks. Hi, good morning. Thank you for your presentation. I found it extremely interesting. My question was with regards to the 2013 companionship interpretation, the federal interpretation. Given the recent overturning of the Chevron doctrine and deference to agency interpretations, and given the current composition of the court, do you see that these more labor-friendly interpretations are going to be in danger moving forward, or is there any literature on the topic, and what's your prediction?
Yeah, I think that's a good question. Thank you. I think now every time we talk about anything labor, the Chevron question is coming up. So on this specific companion exemption, there is also, I'm not an originalist, but there is an originalist argument for the 2013 interpretation is actually correct. Because when the 1974 amendment was passed, before the amendment, domestic workers who were employed by agencies were actually covered by minimum wage and overtime. So when the 1974 amendment was put in, when the companionship exemption was added on, the group of workers who were hired by agencies were actually got worse off. And what 2013 interpretation is moving a wider slide of workers back in, but the predominant majority of home care workers in the current economy are hired by agencies. So even if you just threw DOL interpretations out of the mind, just go back to 1974, asking were they in or were they out? They were actually back then. They were in. What they got out was the DOL interpretation between 1974 and 2013. So that would be how I defend the new rule, but whether it stands, I don't know.
Maybe time for one more question. Does anyone have another question?
Thank you for your presentation. I was curious about what labor organizing looks like among home care workers, because it's not as if they're in a shared professional space with each other regularly, and what that looks like.
So especially for collective bargaining, collective organizing under in the union model, there are two ways to do it. One is the New York model, which the union, especially SEIU 1199, has a pretty strong hold locally. What they do, and there is a part of the agency workforce are just very affiliated with union to start with. So that's what they do is they will go to agency to agency. They will provide training and health care plan and benefits. That's a major attraction to get workers to say yes. And a lot of it depends on whether you can convince the workers of a certain agency to get on board. Another model that's quite widespread, that's true in maybe between 10 to 12 states, is that because all this work is being paid for by the state, what they would do is go to the state legislature, go to the state governor to convince them that this is basically a public sector workforce, and to convince them to pass a state public sector labor law that enable them to get authorized as a whole. But there is a Supreme Court precedent, Harris v. Quinn, 2014, that was exactly about this kind of organizing, but since the Supreme Court's attack on public sector union, now they don't have union security, so you can always waive union dues. But that's still there are the home care workforce in California, in Minnesota, they are all organizing through that model, and they're bargaining for wage and hours with the state. So those are the two models.
Thank you.
If we could just have a final round of applause for Professor Zhang.
Thank you so much for having me.
So we're just going to have a very brief pause, and because we're going to have our next speaker, so we can stay on schedule and track. So if you need to run out and grab some water, but we're going to start here shortly. So.
All right, everybody. We're going to get settled back in. My name is Melody Bohannon, and I use they, them pronouns, and I am the lead articles editor on this edition of Law Review, and I have the pleasure of introducing you all to our next speaker, Professor Ghali Rakabi. Professor Rakabi is an associate member of the law faculty at Cornell School of Law and an assistant professor in the School of Industrial and Labor Relations. He teaches labor and employment law, and his research focuses on the legal foundations of workplace power. His current projects include writing on exclusion from work law, technological change in anti-discrimination law, platform work, and the emerging U.S. student worker movement. We are excited to have him at this year's symposium. Please join me in welcoming him.
Thank you. Thank you so much. So I'm Ghali, and I would like to thank Alyssa for organizing and inviting me to this wonderful conference. Following Professor Zhang is both a blessing and a curse. It's a curse in a sense, it's a really hard act to follow, but it's a blessing because I can now talk about her project, which was actually my original intent. So when Alyssa originally invited me to this conference, I said, you know what I'm going to do? I'm going to talk about Professor Zhang's work because she's right at the intersection of everything that this conference is about. And then, unfortunately, I found out she was also invited. And I was like, okay, so yeah, what am I going to do? And then I have to bore you with my own stuff. But two reasons why I think Professor Zhang's work is important. I think one reason, Professor So, at the beginning of the conference, talked about necropolitics, which is maybe the dominant way in which we do politics nowadays. And I think that what Professor Zhang is offering us is a view of how the politics of keeping people alive, what is it like, and what the image that I always get from her work, that it's messy, it's complicated, it's institutional. We don't want to think about it. It's much easier to think about necropolitics than whatever it is the Latin term is for politics of life. And I love the way that Professor Zhang kind of confronts us with that. And it's beautiful and it's amazing. And the second reason why I think Professor Zhang is super critical, because it deals with these blurred boundaries that we have between periphery and center, between core and the outside, between market and labor and family, between institutions and power. So I love that. Today, what I'm going to present is a paper which is forthcoming at the William and Mary Bill of Rights Journal, which is part of a bigger project that I'm doing about exclusions from work law. And the methodological questions that kind of guides me throughout this project is basically asking what can we learn about work and about law from looking at the margins, what it is that we can take from it. I think that it's kind of in the air throughout the symposium. What can we learn about the justice system from looking at prisons? What can we look at? What can we understand about welfare system from looking at welfare providers? And my substantive theme today, what can we learn about work law from looking at who is excluded from work law? So that would be the theme. So I'm going to start with a case study. The case is called Olson versus the state of California. It's a Ninth Circuit case, and it provides a unique perspective into the issue of exclusions. In Olson, we have Uber, the ride-sharing company, basically seeking an injunction against the application of California's new classification law on its operation. It's a long and complicated story. Uber's story in California is a long and complicated one, but this particular issue, this particular claim, was Uber bringing an equal protection claim against the application of this new law. So to cut a long story short, the state of California, trying to encapsulate Uber within its employee classification regime, enacted a new type of classification legal rule. Who is defined as an employee versus who is defined as an independent contractor. This new framework is called an ABC rule, and the legislative attempt that kind of brought this forward is a bill called AB 5. So it's it's a stricter way of classifying who is defined as an employee and who is defined as an independent contractor. It's harder for employers to exclude workers under this new classification bill, but enacting this law into the state code had its costs. So, for example, the bill or the law excludes from its strict classification schemes, for example, California licensed insurance businesses or individuals, physicians and surgeons, dentists, podiatrists. I didn't know what that was, so I looked it up. Psychologists, veterinarians, lawyers, I knew what that was. Architects, engineers, private investigators, and a whole bunch of sectors and occupations were excluded from the strict classification scheme. Making progress comes at a cost, and those professions or sectors or workers paid the cost or paid the price of passing a new progressive bill. In this hydraulic of political power, when you try to move stuff ahead, you have to give some to win, and those are the sectors and occupations that were given. So the equal protection claim brought by Uber is that your new classification scheme, which is meant kind of to fight misclassification, excludes all of those. All of those are out, but we're in. And that's an equal protection foul. That's an equal protection violation. The standard that Uber kind of pushed forward is kind of a rational basis plus animus. We're going to discuss that. They managed to convince one panel of the Ninth Circuit, but on remand it was overturned. We have a cert petition pending, so we'll see where this is going. So why should we care? Why should we care about Uber's legal trouble? So I'm going to claim that there are all kinds of stakes in Olson versus the state of California that are embedded in some way in all classification issues, all exclusions and classification issues. The first stake is that the California Labor Code is not unique in its exclusions, in its exceptions. It's not a unique phenomenon to find a work law with exclusions. We just heard about home care. We're going to hear about prisoners. We're going to hear about more occupations in my lectures today. All of work law is exclusionary, and if included employers have an equal protection claims against exclusionary work law, then all of work law is basically up for grabs. The argument that pushed my paper is that means that all of work law, all of those exclusions are always operating under an equal protection kind of shadow. The issue of equal protection is part and parcel of how it is that we understand work law. The second stake is following from the first. Work law is extremely exclusionary, and that has significant effects for both those that are in, but mainly for those that are out. We used to think that work law is meant to provide all kinds of economic minimum conditions in the market, and if you're outside of work law, you don't have those. Exclusions from work law tend to track social hierarchies, gender hierarchy, race hierarchy, national origin hierarchies, and again, those that are in are the politically stable, robust, dominant, incumbent groups. Those that are out are not. And in political science literature, in early legal scholarship, we used to think that those two things are aligned. So if you have what is called an economic citizenship, that means that you're part of a community. You have some political stakes in what's happening with the community. The pragmatic implications of that is that for workers who are excluded from minimum wage, don't care how high the minimum wage is. It doesn't apply to them. They won't participate in a March for 15 because they're out either way. For legal analysis purposes, we might care that work law is exclusionary because when courts debate whether exclusions is something that we can live with, yes or no, they look at how much exclusions are there. A case where the Supreme Court did that explicitly is in Hobby Lobby, where they said, okay, there are so many exclusions to the law, why can't you make just this additional one? What's your argument for not carving out an additional one? So an exclusionary work law breeds exclusionary work law, which breeds harms, more exclusionary work law, etc. That's the second kind of stake. In the paper and in the project more broadly, what I try to do is I try to persuade you that, first of all, work law is filled with exclusions, and those exclusions far exceeds the usual suspects of who it is that we traditionally kind of focus on. So it's not just agriculture, home care, and independent contractors. It's all of those sectors and professions in the California Labor Code, for example. The second descriptive argument is about the law, where workers throughout the last 100 years have been bringing equal protection claims under both federal and state constitutional law to fight against those exclusions. And courts have had constant scrutiny of those kind of boundaries of work law, of who's in and who's out. And the normative argument that I'm going to end with is basically we can do better. We don't have to abolish exclusions, but a too permissive approach to when does exclusions become an equal protection foul has brought us here. And I think that there are some substantive and institutional ways in which we can do equal protection analysis better, in a way that would try to curb the authority of basically legislators to politically curb out exclusions, dish out exclusions. So those are the arguments. The paper itself is kind of pretty too long and too cumbersome for me to even remember what I put there. So I'm going to separate that out, and today I'm going to focus on two types of exclusion, which I think kind of brings the issue to factual kind of basis. The first one is in agricultural, and the second is the labor legacy laws, which are the new state and city laws enacted to promote workers' rights, similar to AB 5 in the California example. Okay, so to kind of demonstrate the claim, this is from the NLRA, the original version that was passed, and now I'm reading to you from the findings of the NLRA, the ones kind of why do we need the National Labor Relations Act, and I'm reading from the second paragraph. So Congress is telling us that the inequality of bargaining power between employees who do not possess full freedom of association or actual liberty of contract and employers who are organized in the corporate or other forms of ownership association substantially burden the effects of flow of commerce and tend to aggravate recurrent business depressions by depressing wages rates and the purchasing power of wage earners. So Congress identified the inequality of bargaining power between employees deprived of the rights of association and organized business as a national problem. Like, that's the thing that we got to solve. That's the way that we're going to do it. And yeah, kind of Congress, you got us all kind of hyped up. Let's see how it goes. Okay, so let's go to the definition, right? That's the first place that we go. So the term employee, okay, so we have two kind of entities. We have employees, we have employers. Who are the employees? The term employee shall include any employee. Oh my God, Congress, woo, amazing. And shall not be limited, okay, that we don't care about that. Yeah, and I'm looking at that, but it seems like the definition of an employee doesn't include all employees, Congress. Like I see in the end you say, but shall not include any individual employed as an agricultural laborer or in domestic services of any family or person in his home or any individual employed. So not all employees? So it's kind of confusing. What about those bargaining power workers? Like, what did we do here? The agricultural exemption from the NLRA and from the FLSA is a notorious exemption. I apologize about the typos. I was trying to get this done too fast. It's a notorious exemption. It exists everywhere, both in state and in federal law. The canonical, not critical race theory, fringes hunted down in Florida type of analysis, but the canonical historical account is that the reason why we excluded agricultural workers from the NLRA is because of race. We know that. That was the political deal. We had to get the NLRA and the New Deal done, and that was the price that had to be paid. That's not, again, fringes. That's canonical history of the New Deal. That's what we know. When the state is kind of pushed on it in equal protection claims, the state claims that there are problems with state capacity. It costs us more money to enforce the NLRA in farms than we might get money from, at least kind of weird cost-benefit analysis. And the other argument is that we want to encourage agriculture, and that's the way to subsidize agriculture. It's been repeatedly attacked in courts under equal protection claims, but courts have consistently, federal courts have been consistently pushing those claims out. We know from historical records that this exclusion is about race. We know that it deprives workers of their ability to associate freely and negotiate with employers, and we know that that's a significant loss. We know that because that's what the NLRA is telling us. But they didn't win. No federal equal protection claim about this exclusion won. The most notorious, the most clear violation of an equal protection, clear exclusion because of race, clear implications. We had no kind of wins there. That's in the federal system. We had a recent streak of state similar kind of equal protection niche clauses where workers did win in their equal protection claims against exclusions of agricultural workers. We have cases in New Mexico, in Washington, and New York. Those wins are important. I'm going to talk about why those wins might bring us hope. But they're very state constitution specific and state constitution interpretation specific. Rarely it was the equal protection claim alone that won the day. Usually it was with combination with another constitutional clause or another constitutional value that we need to uphold. And I think one of the reasons or the perspective that I want us to have on those equal protection wins against the most notorious exclusions that we have on the books is that this exclusion has been there for more than 100 years or around 100 years, repeatedly got thumbs up, and those are only 3 states. We have, I haven't counted lately, but we have like 50-ish states. That's not a lot. The reason why I'm telling you this sad story is that exclusions, even exclusions that we know that are wrong, not the new ones that I just showed you, but the exclusions that we know that are wrong, exclusions that we know that are anchored in race-biased kind of political preferences, they're there, and they have an effect. And only 3 courts have managed to kind of do something about it with equal protection claim. Exemptions are sticky. So that's the old ones. That's okay. So you can say that's how politics used to be in the 1930s. You know, we were racist back then, and we had to make those sacrifices to enact progressive legislation. That was back then. That was 1930s politics. That's not now. That's not exactly the case. We have a new line a flurry of state and city work laws, increases in minimum wage, overtime protections, scheduling issues, safety and health, unionization in certain kind of excluded sectors. We have a flurry of those in the last 30 years. A political scientist called Daniel Colvin called that kind of the labor legacy law. Labor has stopped organizing because organizing is too hard under the NLRA, but what labor did was in kind of pushing forward policy initiatives. So what I do in the article, I look at some of those new labor legacy laws, and I look for exclusions there. So we have the regular types of exclusions like size, business size, the sector and occupation. And because those labor legacy laws are often led by unions, we often find those peculiar union strategy-specific exclusions. So specific employers are sometimes carved out because there's a strategy of unionizing that place and we need to be on good terms. There's a case in California where the schedule of who is in and who is out is updated according to the UFCW litigation schedule, like right on the day. There are also targeted employers, so Walmart was kind of a targeted employer in certain California campaigns. So Walmart is either excluded or included depending on the union strategy. So we find this maybe a bit more nuanced idea of how politics translates to exclusion rather than kind of blunt race politics, but politics is still very much there. Okay, so Professor Wakabi, you tell us all about those exclusions, and on paper, it looks a lot, all of those numbers. But what are the numbers? What are the numbers? How many workers are excluded? We don't know. We don't know. The DOL was mandated to issue a report every 2 years about how many workers are excluded from the FLSA. This was stopped in 2000. The DOL was, and the numbers from 2000 was about 60% of workers, depending how you count. That's FLSA. That's the most aggressive classification regime that we have, the most inclusive one. That's not great. It's not great, but it's not that awful. So in Canada, they had a big study on minimum wage and overtime coverage. Their numbers are a bit higher, like 65-ish, depending on the time. But we're not that off from Canada. Again, Canada is complicated. Our regime is thinner, but we're in the neighborhood. But those numbers are not great because the data sucks. We don't know. And not only what troubles me is not only that we don't know how many workers are covered by the stuff that we aim to regulate labor markets with. We have no idea. But we don't know who is covered. We don't know if the NLRA, for example, is still white, or is it black, or who is in and who is out. Are those racial categories that we kind of put in place in the 1930s, is that still what's out there? Are those still the effects of the NLRA or the FLSA or OSHA? We simply don't know. But again, that's a work in progress, and I would be happy to hear your ideas. Okay, so those exclusions are repeatedly attacked by both excluded workers and included employers. Most are adjudicated under rational basis scrutiny, the laxest form of scrutiny. Exclusions from work law is defined almost unthinkably by courts as social and economic issues. All the plaintiffs in the cases that I kind of analyze in the article argue that their exclusion harms them in some basic economic citizenship way, and in all of them, courts say, no, that's just your economic, you're only impacted in economic way, and therefore I'm not going to kind of give that political scrutiny kind of level of equal protection. We have very few successful purposeful attempts to say this is not a strict scrutiny case, this is a strict scrutiny plus. So Uber's case is one of those. So Uber is basically claiming for kind of a selective enforcement type of claim plus animus. So to be honest, the California legislature did kind of custom tailor AB5 around Uber, and Uber is saying, hey, you're pretending this to be a general thing, but you're actually targeting me, which makes sense if you look at the politics. So the first kind of tribunal was more optimistic about those claims. The second one wasn't. So that was an Uber attempt to say this is kind of a rational basis plus animus, or rational basis plus selective enforcement, but very few managed to do that. Some of the themes, when you look at the court cases, there's a strong push of courts to treat what they're doing as justified under Lochner. So the narrative is, what do you want from us, Professor Wakabi? Courts used to interfere in economic regulations in the markets, and you didn't like it then. And this is us not intervening. This is us telling the legislators and politicians, you do your thing, we're keeping out. That's the lesson that we learned from Lochner. There's a significant consensus around that this is a socio-economic issue, this is not a political issue. Significant emphasis on deference to the state and whatever the reason might be, and symmetry that both employers arguing for selective inclusion and employees arguing for equal protection following their exclusions are symmetrically kind of equivalent. There's some weird things when you do constitutional claims through courts, which kind of come to bear once you read enough cases. So the party's identity really matters to the courts. So if a particular employee or union argued something a bit differently just a year before, then that might interfere with their equal protection claim. We also find that employers now have this kind of bucket list that they bring in front of all kind of state intervention in the workplace. So a takings now is very popular. Claim a contracts clause is why not? An LRA preemption, like why not? And now we have also an equal protection claim. It's part of their bundle list to attack work law regulations. And when you read the cases, it shouts out that this is an arbitrary way to decide who is in and who is out. It's unclear. It's kind of explained when do courts elevate the level of scrutiny, and why can employers get this kind of case of one claims and employees can't. It's all messy, and doing equal protection through courts has those kind of themes. Okay, so what can we do if we think that we need to curb this tendency of courts to authorize exclusions from work law? What can we do on a systemic, kind of nationwide attempt to say, no, actually we have a preference here, and the preference would be that workers would be included rather than excluded. It's not that we're ambivalent as to those options, but how do we kind of curb the arc of history towards justice? So one type of attempt is to try to define exclusion and inclusion in political terms through a lens of economic citizenship. There's something inherently political in my ability to earn a minimum wage, be part of a union, and be protected from disease in my workplace. There's something inherently political in that. So that's one avenue. Another avenue is to look at the very structure of work law. So the NLRA is clearly kind of argued to be universal but carved out. So maybe we can use that structure of work law to argue for a congressional preference towards inclusion rather than exclusion. So law is not ambivalent with regard to the lines, but it has this kind of preferences. We can try to again push again and again against this core tendency to be deferential to the state when it says the reason why home care is out is because we want to subsidize care, and that's like fine, okay, let's do that. Or the reason why agriculture is out is because we want to subsidize farming or food production in the United States. We're going to say, no, that's not it. If you want to do subsidies, then you can do subsidies. You don't have to carve out workers. And as my push is to kind of open the floor for suggestion of how can we create this or puncture holes in this line that courts draw between the political and the socioeconomic. Institutional mechanisms, I don't think that our current Supreme Court would read my article and would be, oh my God, eureka. Maybe in the case of Olson they would side with Uber, but that's not exactly what I have in mind. So what other institutions do we have? What else can we do if I don't think that Justice Alito will be on board? Well, first of all, federal government provides subsidies to multiple work law initiatives in state and city, and those subsidies are often conditioned in all kinds of terms. And we can imagine the federal government saying, yeah, you know what, you should count how many is included and excluded from your unemployment insurance program, and if it's under 60, 65, 70, whatever of the workforce, then you won't get subsidy, you'll get less subsidy, for example. We can try to convince unions that inclusions and exclusions really matter, even outside of their membership, and we can try to educate and create strategies within our union allies about why custom tailoring work laws to your organizing campaign in Walmart is really important. I don't question that, but maybe there are other broader goals that the union movement should kind of promote. And we can think about state courts. So I gave 3 examples. Those examples are not kind of were brought us from the heavens, but were a product of decades of organizing and fighting and kind of legal innovation on the ground. And that means that they are reversible. Those wins can be overturned, but the optimistic way to look at it, those can be replicated and expanded. And we can use state constitutional law interpretation as a sort of a mirror image, or maybe a murky mirror, but a mirror nonetheless to the Constitution, to the federal constitutional law interpretations. So that was me, and I look forward to your questions. Thank you so much.
All right. First of all, thank you for your presentation. Regarding, I guess, kind of using the federal government as an institution, I was just wanting to kind of get your thoughts about to what extent, the agencies, like the NLRB, could be used as opposed to, amending the NLRA, which I assume would be a much more difficult task.
Yeah, I think that's great. And very, very innovative. I think, so for example, the EOC creates a yearly priorities list for their enforcement. I think it would be beneficial for the EOC to know who's in and who's out, in which state and which sectors. That might, kind of enlighten them as to their enforcement priorities, where it's more important, which sectors, which occupations do we even have authority to begin with. And the EOC often works with state and local fair employment practices agencies, and I can imagine a world where they strive to kind of complement each other's capacities in terms where it's either murky as who is in and who's out, or in those kind of creating enforcement priorities. So that's one. The second example is from the board. So the board has authority to cede its authority in certain cases in local or sectoral instances. So ceding that authority can create new opportunities for state and city type interventions, but the best way of doing that is first knowing where it is that it would be effective for me to cede authority, where it is, but currently they don't think like that. That's not the way that they engage in their enforcement or adjudicating kind of practices. Does that make sense? Thank you.
Awesome. Well, thank you so much for this, Gali, and it's both having Gali and Yoran here is so exciting because you're doing the most interesting work on home and care right now, and Gali's doing really cool labor law work, including, for those of you who took labor law with me or who will, a new article called Balancing is for Suckers. And if you take labor law, it's a lot of balancing where the employer just happens to win, right? And Professor Rakabi would have us get rid of some of that and make it more worker-friendly. So it's really interesting to hear this. And so a comment and a question, and the comment is this kind of, the Uber's approach here fits with me with something I think we're seeing across law in other areas, which is as society is changing right now, the sort of reconstructing power is vulnerability, right? So we see this in cases like Hobby Lobby or 303 Creative, right, where powerful, historically privileged religious groups are framing themselves as being vulnerable and therefore needing special rights and the like. And now Uber is bringing an equal protection violation. So to me, it's part of a broader theme where those who are historically powerful are using slightly changing conditions and the threat it causes to reconstruct themselves as vulnerable. My question is whether or not economic citizenship, if we're trying to rethink the equal protection doctrine to do good work and then maybe not to do work for Uber, which seems pretty fine, is the only lens? Like, could we think of this as through an anti-subordination lens? Might that get more at what we're talking about? Should we think about it rather than economic citizenship as through an economic power lens, right? Historically, less powerful parties are like, so just sort of an invitation to think through whether or not economic citizenship is the only lens, or maybe whether these other lenses might fit under the umbrella of it, or how you might think of that.
Yeah, thank you. So I think power is a complex thing, and I think Uber's argument to being powerless vis-a-vis the California legislator makes legal sense because the politics of it, and Uber kind of had a great case demonstrating it, where a captured legislator is abusing its power against a helpless company. And not just a helpless company, but important for Uber, a company that the people of California supports. So it's kind of Uber won its ballot initiative as to who is classified as an employee in the contractor in California. So this argument for prosecution is kind of resonates. It resonated with the Ninth Circuit judges, and it makes sense. What I try to do with economic citizenship is take a step back from work law is the thing that should protect us from harm. I'm a victim, work law, protect me, and move it to a more kind of democratic, participatory thing. But I'm not sure that that's a coherent kind of political theory that I'm bringing forth. I also think that this part in my paper, and I think in most papers, kind of the suggestions part, is the weakest one. It's the most theoretical one. It's the most kind of dreamy, let's imagine. I think it's important for us to imagine stuff, but that's the part that I kind of struggle with, finding legal coherence in. I think that what I try to do in this part, and that's the only reason why those imaginary parts are interesting, because they tell you what I think about the law, and I try to ratchet up scrutiny, and I try to say, no, quote, when you say that this is a socioeconomic issue, the difference between that and a political ratchet for an equal protection claim is murky, and we should kind of bounce those claims up. I need to think about it, but I don't see anti-subordination or economic power theories by themselves do that move. But I need to think about it more.
All right, I think we have a question up in the balcony.
I would like to share a Virginia experience.
Go.
During COVID, I had a brother in a nursing home, and I want you to hear me. A brother in a nursing home where 50 patients ultimately died. When COVID first got on the news, they weren't giving tests to the patients. I called the governor, I called Trump, I called every senator, and ultimately I was put on the governor's task force for long-term care facilities. So we met on a regular basis, and because I know my brother needed care, they were not concerned about labor. I said to them, let's put together an emergency labor force just of nurses. When the nursing homes get short of care, that they would have a pool of labor. I was told the purpose of the money for COVID is not for labor. The purpose is to make sure that the nursing homes that had the most loss from death would be paid. And I guess my biggest concern is I have a fetish for working on improving labor at nursing homes. And I guess my point is, what do we do with the aging baby boomers like myself? And we wonder, what is the labor force going to look like for us if we are in a nursing home? Medicaid, Medicare. So if you can address that, and I wanted to make my comment when you were speaking. We got the eye contact? Okay, thank you for listening.
So thank you for the question. I constantly dumbfounded by how much pain COVID involved. And it seems like so long ago, but I think we were kind of repressing all of that pain and death and anguish and stress. I do think this is more a Professor Zhang kind of question. I would just give my spiel, is that one of the functions of exclusions is to deal with those stuff, the stuff that the state needs to get done. So we subsidize those stuff that needs to get done by exclusions. So prison labor, again, classic example, home care work, agriculture, we all need to eat, so we'll subsidize that via exclusions. And the reason why those exclusions are sticky is because we got addicted to this way of doing stuff. We got addicted to not thinking about labor because those are affected, in any case, are those that we don't see, don't live by, don't have access to the political. So that's my exclusion spiel, but I'm sure Professor Zhang can have.
So first, thank you for sharing your story with me. Like, what I appreciate about doing this research is that I hear about stories about care, struggles with care, crisis of care, and I really appreciate when hearing the personal experience going through that. So the way I think about it is that I think COVID, there's a lot of discourses about crisis of care during COVID, and it's true, it was a crisis for many, but I think it's also
a revelation of what's structurally troubled in the care economy that's beyond COVID, that COVID just surfaced a lot of the tensions, the deficit that's already there, and surface it for workforce reasons, for care reasons, for family reasons. And when I think of the big picture, how to make the care workforce better, how to make the care economy better, I always arrive at a conclusion that I think doesn't politically fly. It's that we need to pour more state money into it. We need more public funding of care, and we need to make sure that public funding is actually ending up in the labor force. And because there are two sides of it, that not all the people needing care is getting it, and care workers not getting paid enough, and not getting paid enough to stay in that job. A lot of home care jobs, workers I talk with, the impression is this job was not created as the winner job. It's created as a subsidiary, as a part-time job, not something that can sustain a family on it. But that's not the reality for most workers who want to do this job, who will do this job. And we need to we need to transform how the job looks like, then we can attract enough people, can retain enough people in the workforce to provide quality care for people and families who need it. But again, how much that can convince politicians, add funding legislation is a different question.
Thank you very much for this presentation. I remember, I don't know when it was, 15 years ago, when the gig economy was heralded and valorized as evidence of freedom and flexibility, often by liberals, many neoliberals. But I'm curious about your optimism on reform when Kamala Harris's chief advisor is Tony West, who is general counsel for Uber. And Uber is also, I think, has a ballot initiative in Arizona or
Massachusetts.
And one in the Southwest. They're going after legal fees. So I'm very disturbed by his proximity to her, and I voted early for her. So this is not an attack on Kamala Harris, but the political landscape is incredibly neoliberal still. So what's your optimism on this?
I'm not optimistic about Tony West's impact on Kamala Harris. No, that's not my my best case scenario for a Harris win is that she would let the labor workload pockets of the Biden administration keep churning and won't touch that and even protect those from attacks. I think that that's the best case federal scenario that I can imagine. I think in the state level, we can have room for very cautious optimism. In one of my ongoing projects, I do a 50-state kind of survey of Uber-like laws. So we have Uber laws that either kind of explicitly say Uber drivers and independent contractors deserve nothing, or condition that with basically signing a contract. So we have those in about 36 states. We also have about 10 states that regulate marketplace contractor laws, MC laws, which says that all work done via platform is by definition done by an independent contractor. So there are fights that are being held in the state policy level, and in those fights, workers are losing. So my concern is both in the federal level that I don't see a lot of progress for Uber drivers there, and in the state level, Uber and the Chambers of Commerce and conservative allies have been really efficient in lobbying for those kinds of laws, extremely efficient. And we have now full coverage. 50 states have those kind of laws. Only 36 of those treat employee status directly. But that's also not promising. One of the things that those laws do is prevent cities. So 44 of those laws preempt local and city initiatives because they know that if blue cities might win some stuff. So that's also not promising. And I think that for Uber, kind of this concrete case of Uber and marketplace contractor laws, there's a really tough choice, strategic choice about what to do. Their fight for inclusion through the courts, through legislation, has failed. The political will is not there, the courts are not there, and now they have a strategic dilemma of what it is that they're going to do. And it's really tough. This dilemma was never easy. Being an employee in the US is not that great, especially when Uber told them that if they find as an employee, what they're going to do is they're going to franchise them and they're going to tell them when and where to work, which they don't want to do. So it's always a hard strategic dilemma. And what I try to do in the paper is say, well, all of those really hard kind of soul-crushing strategic dilemmas are happening in a structure. And that structure is that the courts pretend that we don't have a preference whether Uber drivers are in or out. And I think that we can do better with the equal protection. We can say, no, actually, we do prefer people to be in. We do have this tilt, a nudge, something that would make it harder for people to be excluded than for it is to be people to be included. Kind of hate the game, not the players kind of thing I'm trying to do. But the story for Uber is a sad one. I completely agree.
All right, we have time for one more question.
What's the pitch to unions for why they should support employee workers?
You really care, unions, about immigration, and you really care about minimum wage, and you do that not just because your membership is coming from outside the US, and you care about minimum wage because rising tides lifts all boats. We should treat the definition sections of work law the same. By ignoring parts of the labor market, that doesn't mean that they're not there, and you could lift more boats by including more people. And I think that should be a policy priority. Unions can do that. They are doing that in some cases. But it should be a policy priority, even when things get really important, like AB 5. Yeah, that's my...
All right, thank you so much. Let's do another round of applause.
Thank you so much.
All right, so we're going to go into lunch now. Lunch is going to be served in the atrium, and we're all going to try to be back in this room at 12:40. You can eat in here if you'd like, but you can also go into the Law Commons, which is past the atrium, or outside. It's also good weather. So we'll see you back at 12:40.
All right, so I think now is probably about a good time to get started. Good afternoon, everyone. My name's Connor Johnson. My pronouns are he, him, and I'm the online editor here at the University of Richmond Law Review. And it's my great pleasure to introduce Danny Zemmel. Danny is a litigator at the Crudis Law Firm. His practice is specialized in appellate advocacy in the Virginia Courts of Appeals as well as the Fourth Circuit. And he is regarded as an especially excellent appellate attorney. Mr. Zemmel has litigated claims in local jails, regional jails, juvenile detention facilities, state prisons, and federal prisons, covering claims involving excessive force, denials of medical care, and other appalling conditions. His firm's website offers a telling quote about his character that I personally appreciate and can attest to, which is as follows. Danny is drawn to those civil rights issues that will define whether society courageously steps forward or fearfully lingers in the past, and he will always tenaciously advocate for those who seek progress. Today, Danny will be discussing involving incarcerated people in the political process and procedural hurdles that can happen or that are present in the field in the kind of litigation that he practices. And at the conclusion of his presentation, there should be some time for Q&A. Please join me in thanking him for his time today and welcoming him to our symposium.
Thank you very much, and thank you, Alyssa, for setting this up. For those of you who don't know, Alyssa's put a lot of work and a lot of effort into this, and has done a phenomenal job. And everyone else who I don't know as well, thank you for all the work you've done as well, too. A couple quick disclaimers before I get into this real quickly is that I am still relatively new to this work. I've been working for 5 years now since I graduated from this school, and much of that time was during the shutdown. So there was a lot in terms of like talking about community or movement type lawyering that was even more difficult when I was just sitting in my room writing briefs for 2.5 years, which I actually enjoyed, but that's me. But one of the things that was mentioned by Professor Collins earlier, and the reason we want to get involved in this is that one of the major points of extraction are prisons in this country. I think in the ways that Professor Collins was speaking about before and in many other ways. And what brings me to this, though, is something that having worked at this for a while and being lucky enough to work with the Legal Aid Center here and some people with your Hill from in the next panel about movement lawyering and learning more about community and movement lawyering, which I will go to in a minute. But that's very difficult, for obvious reasons, for people who are incarcerated. Something that I've struggled with a lot as I started to work is that, basically I only hear about things when someone calls us or something horrible happened to them. Maybe their public defender calls us, a family member. We don't really have a way of kind of being active preemptively in the community in that relevant community. So real quickly, as we go through this, I want to distinguish a little bit for those of you who aren't as in prison litigation as I am between a jail and a prison. I'm going to be speaking about prisons here today. Jails, the local Richmond jail you might know, or I think they call it, oddly enough, the Community Justice Center or something like that. The Richmond jail, local jails or regional jails we have in Virginia as well, where some regions group together, are going to be where people are held when they're first arrested, waiting trial as a general rule, awaiting sentencing, or again, these are general rules about a 1-year sentence or less you might stay at the jail. Everything else is going to be sent to either federal or state prison, and I'm going to be speaking here about the state prisons, which are run by the Virginia Department of Corrections, which I call VDOC. What I'm going to be speaking about is a lot of this is federal law and governs most of the country, but my experience specifically is working in Virginia, and so I'm going to be focusing much more on the specifics of access in Virginia. And so quickly before I move on to the next slide, just a little background. That is the Allegheny County Jail, which is just the first jail in Pittsburgh that I ever went into, did some work in as an undergrad, and I think probably is what started me along this process. Aha. So, movement lawyering. I looked down as if my paper was going to move too. Movement lawyering here, I'm still fairly new to this, but I wanted to there's a lot of different definitions about what movement lawyering means to people. This is one that's always really stuck with me. I say always. I read it about 2 years ago, so I guess it's not that long. And so you can give a moment to move it. But to me, the big aspect here is that the law is trying to build collective power. We are not trying to use the law as a tool. The way I would think about it is that the law is not an end in and of itself. It's a means to an end. And the idea of litigation success as an end. And that the other big thing to me, and what I'm focusing on here, is that it must be led by those most directly impacted. I have a certain set of knowledge about how prison law works and those kind of things. I am not an incarcerated person. I have not been incarcerated myself. I don't even have family who are incarcerated. I now have many people I count as close friends who are, but that only is through my work. And I think that, and so I think it's important, especially in this context where there is so much separation often between, and it's that you have, that you work to make sure that the people who are incarcerated, who are behind bars, are the ones leading what we're attempting to do, as opposed to, patronizingly working on their behalf. But as may be obvious in the prison context, this is, I think community organizing, as anyone can attest, is very difficult to begin with. It's super difficult when you cannot contact the people you're trying to speak with. One of the classic models, and again, this is still newer to me, of movement lawyering or community lawyering is trying to have, make sure you have constant input and meetings with community, that you are learning from, community members, from the impacted people, what's affecting them in their life and what they want to be happening. Again, I'm not allowed to walk in, a community organizer cannot walk into Sussex Prison, which is probably one of the closest ones, and just ask to speak to a bunch of people and see what's going on. That's not going to be allowed. And so not only is the ability to communicate very restrictive, I'm also going to be talking about is that the First Amendment, for the most part, does not apply in prisons. I'm not a First Amendment expert. There's a lot of caveats to that. But their communication is very restricted, and is both restricted and censored and monitored. And so not only do you have the issue of speech full-on being rejected or being not implemented, you have the issue of punishment or collective retribution due to attempts to do any kind of social organizing or movements within the prison, any kind of collective organizing. So what I'm going to do is try to go through a little bit briefly, some of the issues about that and kind of explain why, beyond just the physical removal, prisoners are very much, incarcerated people are kept out of the political process. But before we go into that, really quickly, I think it's worth reminding, it's very much an understatement, but that prisons are really horrible places. I'm not here to try to be too much of a convincing in that aspect, but I think that I'm going to go through a few statistics and stories briefly to kind of center that. But I think it's worth mentioning and remembering, it's something that I hold very dear, that none of these statistics or even individual stories truly demonstrate, I think, what I consider a stain on our society, that we deal with issues like this by throwing millions of human beings in cages, which is what we're doing. I think it's worth remembering that there's about 2 million people in this country currently in a cage, and that's the way that we're dealing with things. That, by the way, is Sussex Prison back when they still had the death penalty there. Not anymore, thankfully. Okay, so a couple quick numbers just about Virginia to situate this. I think it's worth, again, situating this here. About 1 in 150 people in Virginia at any given time are locked up. So this is, if my math was correct, so I might, if someone's catching me on that, it's about 1 in 150 based on our population. And as you can see, it's about split half equally between the state prisons and other options. One thing to note about the local jails, that number is going to fluctuate all the time, day to day. The average stay there in some of these jails can be only a day or two. And so, the day you look at the jail populations, state prisons and federal prison populations are much more standard. They move people around within the state, but the overall prison is pretty standard. Also, and I'm not going to be talking too much about this, but it's also worth remembering when we talk about these things, there's also an equal number of people who are under some sort of government censorship or control and monitoring. Probation is a general term used for that as well. Now, the other thing I think to point out about this before we move on again is that, like a lot of problems in our society, this does not fall equally across race and class lines. And I think one of the easiest ways to see this, again, in Virginia, is with this map. So I'll give you a second to try to look. If you can't see the legend there, this is showing that you can see the darker the blue or the darker the color is, more people as a percentage go to prison in those census tracts. So these are split up by different census tracts, as they call them, so about 100,000 people per tract. And for those of you who aren't as familiar with the Virginia geography, you can see that in the top right corner, with one tiny exception, near northern Virginia and some of the richest suburbs, we have a very, very low incarceration rate. And in Virginia, or in Richmond, right near in the middle, you can almost directly see the split between the city and the suburbs and the racial divides in the city right along those lines, for those of you who are familiar. Again, the same is true out in the Virginia Beach area and in the rural, poor, white area in southwest Virginia. And so I think this map very clearly shows that impact from mainly racial but also economic lines as well. And just to put a finer point on that, here it is in numbers. So I think we need to keep these numbers in mind, that despite making up, and these numbers are a few years old based on the last census, so it could have fluctuated a bit, but less than 20% of the population in Virginia at that time identified as black, and about 54% made up the state prison population. So that disparity is massive and a problem, of course, and I think it's important whenever we talk about prison context to keep these numbers in mind, that this is especially when we're talking about what speech and what organizing is allowed, that there's a racial aspect to this as well, whether or not it's in the laws. Okay, so getting back to what I'm ostensibly talking about here, I wanted to put aside a few things quickly. I think the most things that come up here when people talk about political process with incarcerated people are voting. So like felon disenfranchisement is the most common one you may hear about, or the fact that even in many states where you're allowed to vote while you're in jail or something like that, there's no practical mechanism to do so. Is another big issue. There's also what's called prison gerrymandering, where people who are counted for the purpose of the census and for voting in the location where they are being incarcerated, not where they're from, which means that wherever the prisons are get increased political power, and the areas where people are being taken from lose political power. Virginia is actually one of the states that tried to remedy that recently. And again, I think the map showing the change, real quickly, just to put one more point on that, this is the change in political apportionment in Virginia after that change was enacted. So again, you can see that the urban blue areas gained political representation, and a lot of the more rural areas lost it. And this map, pretty well matches the darker orange, or mostly where a lot of the major state prisons are. Okay, so there are three basic categories, or three basic ways that incarcerated people are prevented from participating in the political process beyond just voting, and more, I'm talking about more broadly speaking political process, the idea to exchange ideas, information, encourage people to advocate on their behalf, any kind of other, political action, advocacy of any kind is very restricted. There's three kind of traditional aspects of this. There's traditional censorship, book banning, things like that, just full-on rejecting a mail being sent back and forth. There's the chilling of speech, which I'm using not quite in the same way as the First Amendment. I mean, a little bit of that comes obviously from the First Amendment idea, but again, it's more about the kind of arbitrary amount of control that goes on in the prisons here, and the constant fear of retaliation, which I will get into a little more. And then there's some of the practical limitations, which largely have to do with the remote nature and of the prisons and the lack of money for many family members and people themselves who are incarcerated. Okay, so this is not a law class, and I'm giving very short overviews of pretty large substantive areas of law, so please, if anyone's very familiar in these areas, don't get mad if I'm missing some caveats, but these are, broadly speaking, there's what I call traditional censorship, but actually at this point most prison regulations are governed under what's called the Turner v. Safley test, which basically just means they have to be reasonable. So prison regulations that restrict speech, with a few exceptions related to religion, if they're reasonable, and that's in the eye of the federal court, which already gives a lot of deference to prison officials already, it will be allowed. Interestingly enough, in Turner itself, cases from the mid '80s, there were two provisions at issue. One was a regulation disallowing any form of communication between people in prisons in Missouri. So if they were in different prisons, they were not allowed to communicate with each other. And then the other one was that they were not allowed to get married without prior approval from the wardens. The communication between prisons was upheld, or actually was considered presumptively reasonable, and it was remanded to the state to determine whether any of the individual people had a claim. And then the marriage law was actually struck down, regulation was struck down. However, that's the last time the Supreme Court has struck down any prison regulation in this context. And this governs basically all speech in, out, and within the prison system. So I want to use banned books as an example really quick, because I think they're one of the most obvious and kind of easy to recognize areas of censorship. And I also think that this shows the kind of arbitrary, both the arbitrariness of these books that are banned and the amount of deference, the amount of control that prison officials have in this context. I think is very important as an example of what I was talking about before. I think it's hard the amount of control that goes on in the prisons. I think for those of us who aren't in there on a day-to-day basis, it's hard to imagine kind of how much control over your daily life and all aspects of your life go on when you're incarcerated. Or maybe it isn't for some people, but all aspects are controlled, and they have the ability to make your life significantly worse in many ways if you do things that are not well liked. And I think that looking at the banned books, the type of books that are banned, and the kind of lack of real reasoning that is needed to be given to uphold them, even when challenges are brought at the courts, is really indicative of that. I think the most famous example that people might be familiar with is the Dungeons and Dragons example. It was banned. It's actually banned in most state prisons across the country, but it got to the Seventh Circuit in a case, I think, in 2012, called Ramish, if anyone wants to look it up, and the Seventh Circuit said, sure. With the famous Judge Easterbrook on the panel, they said, yep, the prison officials say, and I quote, there was one prison captain who said that it was intended, this policy prevented cooperative games because it can mimic the organization of gangs and lead to the actual development of gangs. And the D&D can foster an incarcerated person's obsession with escaping from real life, thus hindering rehabilitation. The Seventh Circuit said, you know what, that sounds kind of like, actually that doesn't seem very reasonable to us, but it doesn't matter because that's what the prison officials said. There's other experts, they made a line that was like, other experts may not like that. And again, I'm not, going through litigating those cases. Well, I just want to point out again, I think it's very important to remember that that kind of reasoning that I think most of us would acknowledge is fairly specious is upheld. It's hard in other contexts too. And if anyone cares, Virginia also bans D&D materials as well as Magic the Gathering. Also, in almost all the facilities, though, you can still watch TV. So as you'll see, I'm going to go through, there are some pretty interesting banned books, and one of the ones the most common, if you go through the list of ones that are banned, is usually sexual or violent material, but again, cable television is A-okay. As I said here, if anyone's interested, the Marshall Project, Phenomenal Journalism Project, put together a list the best they could using FOIA of banned books. It's also a hard thing to put a list together for because most states like Virginia don't have like some presumptive list where they read everything on Amazon. They look at everything on Amazon and say you can and can't get this. It's more you have to request to have a book sent to you because you can't have you can't send them from the public. I'm not allowed to send them. It has to come from a publisher. And they will then sometimes say, no, you don't get it. Also, it's very hard to see any kind of established rules about this. For instance, many of these books I'm talking about have been requested, denied, requested again the next year, accepted. Someone else requests them 2 years later, they're denied. There's a lot of variety to the point where the same person might do it multiple times and get different answers. But a few of my favorite ones that are currently banned, at least as of 2023, all of the George R. R. Martin books. We've also got It and one of the lesser known and not nearly as good Michael Crichton movies that they made into. I think they made that one into a movie too. The famous religious text, Pilgrim's Progress. I've actually been trying to figure out how that one is also banned given the strength of religious practice, but I haven't been able to figure that one out. And the Physician's Desk reference, also one of my personal favorites. I'm not really sure what they're worried about with that one. So those are just examples. There's a lot more if you want to go through and read it. Okay. So, other correspondence beyond just books that we're talking about. So, the main ones we're talking about here are going to be letters, is the most common thing you're going to be thinking of. Email, or I guess it's not really email, they call it e-messaging because they don't allow them to access regular email inside the prisons, and phone calls. And under Turner, there are, the regulations are make them allowed to ban or certain types of speech from going out. They're allowed to full out reject, and I'll go through some of those types later. But I think the important part to note, because they are allowed to ban certain things, they have the right to read everything. They have the right to read and censor everything going in and out. And so again, in terms of community building movement, imagine if you're trying to build community, but when you're trying to speak with someone, everything has to go through the people that you're basically trying to organize against. They give these very obvious incentives that create problems for that make people very unwilling to be honest about things that may even seem very kind of innocuous when they're writing in these aspects. And what I'm going to discuss a little bit later as well is that the disciplining can be very strong for this. So while you cannot be criminally charged for violating internal prison regulations other than the ones that mirror outside criminal prohibitions, you can still face severe punishments that can be a real restriction on your liberty, and I will discuss those a little bit later. But so I think it's very important. Also, for anyone who's like a procedure nerd, these are all deemed regulations, but VDOC is not subject to Virginia's APA, and that's true of, I think, every state but one. Prisons are exempt from food regulation, safety, from APA things. There's no notice and comment. There's no, that's a separate list that I'm not here for, but it's, it's pretty bad. So that's something else as well, which also means that these regulations can change at a whim all the time. And the web page that hosts them, I think in total, the number of pages break. I think the ones that you are allowed to view as the general public, I think break 2,300 pages. So it's a lot. And people are expected they're in trouble if they break any of these rules. Okay, so here are some of the things that you can be punished for in the Virginia Department of Corrections. Participating in any form of group demonstration. So whatever they deem to be a group demonstration, under the terms of this law, this regulation, singing happy birthday would be a group demonstration. Possessing a cell phone, refusing to work, disobeying an order, so anything the guard says to you, whether or not it's a lawful order, there's no defense there, and using insolent language in the presence of a non-incarcerated person. Those are just a few. There's lists go on and on. So there's a lot of regulations. The other one, again, going back to the kind of racial makeup of the prisons, the other one that you see a lot of issues with is using or attempting to use codes, signs, dress, or other outward manifestations of gang involvement or association, which often just means you're wearing the wrong hat, you're wearing the wrong color or something that they will assume. And again, this is often very much racially biased. And so you will see, unfortunately, much of what I'm going to be saying about here comes from, unfortunately, I don't have numbers for these. The Department of Corrections does not keep numbers. They are not mandated to keep numbers on discipline given or anything like that. So much of what I'm going to be discussing comes from personal experience and from other lawyers who've done this. There is a new law that puts an ombudsman, as it's called, for the Department of Corrections, that part of that means that they maybe will start keeping those numbers. It's a little bit ambiguous, but so maybe we'll have more numbers on this in the future, but right now it's entirely, they do not keep numbers on these aspects. All right. Okay. And like I said before, the punishments can be very severe. So you can have your visitation rights taken away from you, which is one of the most important ones. So like I said before, visitation is already hard, and we will get to that, but it can be entirely limited. You can lose access to the commissary, to phone. One of the biggest ones is solitary confinement, or I guess they call it restrictive housing now. They don't like that phrase anymore, but it's the same thing. And that can be for a long period of time. You can also lose your good time or earned sentence credits. That's a separate, the sentence credits are a big issue right now. If anyone's following that, it's a very big battle in Virginia. I don't quite know or go into all the different types there, but the basic idea of different types of good time credits or earned sentence credits is that if you have a 10-year sentence and you serve, for every week that you serve, if you commit no disciplinary infractions, they might add an extra day off. Don't quote me on these numbers. Those numbers are definitely not right, but that's the basic idea of a lot of these. But the prison can take those away. So again, if you disobey an order, and again, here it's going to be the officer or the guard who said you disobey their order, their word against yours, and you can have, for disobeying an order the first time, they usually won't take away good time credits, but 2 or 3, they might. They, again, could take away money, and so that's very, very big here. The other one is the monetary fines, and I wanted to bring this up in connection to a lot of the labor that we've been talking about here. The monetary fines are about $15 or $25 usually, which does not sound maybe like a lot of money, but you have to remember that the wages for those people who do work inside prison is going to be about 25 to 40 cents an hour currently in Virginia. The highest paid job will be 80 to 85 cents working for the Virginia Correctional Enterprises, which, for any of you who went to a state university, they likely made your dorm. There is a state law that requires that articles and services produced or manufactured by persons confined in state correctional facilities, so incarcerated people, shall be purchased by all departments, institutions, and agencies of the Commonwealth which are supported in whole or in part with funds from the state treasury. And so public defense office, prosecutors' offices, and most notably, I co-teach a clinic at UVA, and most of the material there in the school is produced and built, or at least the first bid has to go to the Virginia Correctional Enterprises. And that's the highest paid job, and they get 85 cents from some of them. So when we're talking about, this photo specifically is, by the way, is from George Mason, but I believe that these are the same ones that they have across the Commonwealth. And so again, when we're talking about, that's not as much my expertise, but I think it's definitely worth remembering that prisons are one of the, highest points of extraction of labor, and, in Virginia they get paid almost nothing. Some states don't pay people at all, which is still, unfortunately, legal. Okay. A lot of lawyers or soon-to-be lawyers in here might be thinking that, these disciplinary hearings are taking away people's liberty. You're putting them in solitary confinement. You're having them stay longer in prison. You're transferring them to a different prison. You're not allowing someone to visit them. That, the due process clause might come in. There are due process rights in prison. Again, this is an area that could take, probably a couple different classes of an entire semester of a class, and something that I don't think anyone quite understands because it's been very unclear. The last Fourth Circuit opinion on this actually started with, "We struggle to know what the law is," or some line like that. But the main thing here is that you have no right to a lawyer. You have no right to present evidence if the hearing officer doesn't believe it's relevant. You have no right to call witnesses if the hearing officer doesn't believe they're relevant. And that hearing officer is a Department of Corrections staff member, and that hearing officer has the ability to make the decision and to impose punishment on you. And your only ability to appeal is to other Department of Corrections members or staff members. So I think that interestingly enough, the other thing that comes up in this context for those of you who do a lot more criminal work is that because of the severity of some of these punishments, you also have basically effective a plea bargaining system. They call it penalty offers inside VDOC, but so the same because you're almost guaranteed to be found guilty, which is the phrase they use, even though it's not really a criminal proceeding. They will come to you and say, here's a lesser punishment if you accept, and we don't have to go through our hearing, and people will usually say yes for the same reasons they will on the outside. And so there's the same issue. Again, anecdotally speaking and talking to people, these numbers are probably as high as 90% are solved that way, but we don't have any numbers, so I don't know. Okay, and then the other thing that people might look at is, again, since there are some disciplinary, some due process rights, does the court review this as well? And the answer is mostly not. I think solitary confinement is one area where there's becoming a lot more coverage on that, but again, it's not very fruitful. The two big areas that you see, which I think is also where the penalty offers come in, is that the courts have held that visitation rights, or most courts, including ones in the Eastern District of Virginia and Western District, have held that visitation rights and the amount of the monetary fines are not significant enough penalties to trigger the due process clause, that those are not protected interests. Not all circuits have held that, but there's currently, so for many claims, if you receive a monetary fine or if your visitation is restricted, that's not reviewable. The federal court will just say, we don't review that, and the state courts in Virginia say that they don't have jurisdiction over that anyway. So that is so again, you're very rarely going to get court review. And I go through all of this again just to point out that this is essentially an authoritarian institution inside the prison. I think that's, that phrase has been used a lot in law things, but so when when I say fear of retaliation or chill of speech, I think it's important to recognize, that this is, everything is controlled, and there's no kind of backstop that we think of, oh, well, they can't do that or something like that. They can do it inside the prison. That is not really something that you have to worry about if you're a prison staff official. Okay, so last thing, other barriers beyond the law. Anyone who knows me should not be surprised I'm sweating. There are three of them. Prisons are remote. That they are keeping in touch can be very expensive because they're remote, and the visits can be very traumatic. And I think this is something else that people often don't think about and we'll get into, but that, they say that, well, you can just go visit someone in the facility. You hear that come up a lot when there's talk of the phone or video costs, and I think people undersell what it's like to, I have trouble seeing people I consider friends, behind bars, going through that process, being searched on your way in, all those kind of things, being strip searched depending on what it is. And, I can't imagine if that were a family member, a loved one, that process of seeing them in those kind of situations can be really hard. And especially when it comes to children, that's often something that comes up. Okay, so I wanted to include this actually because of what Professor Collins was saying earlier as an example. She mentioned that a lot of these are built on former coal mines. Red Onion State Prison, the biggest and most notorious one in Virginia, is exactly that. It was donated to the state by the Pittston Coal Company. They also, I don't exactly know where the donation comes from. I've never been able to find that out, but why they donated. They did retain mineral extraction rights, so they do actually still extract minerals from the area around that. But so this here, that's exactly what we're talking about. This is one of the most rural parts of Virginia, right on the border with Kentucky and North Carolina. The last time I drove there, it took me 6 hours and 10 minutes without traffic from Richmond, which is where I live. So it is a very, these places, not all the prisons are quite that far, but Red Onion, I think, is an example of showing that, this is exactly what happened. The area there was extracted. It was pushed by the local board of directors there. It's Wise County. Were pushing to make sure that, because it was money. It's a huge economic boon for the city, or for that area. I don't know if Wise is counted. I don't quite, it might be unincorporated. Okay, and then really quickly, I put this map up before, but to show again on the remoteness, for those of you that aren't as familiar, the prisons are basically all along the North Carolina border moving over to the west. Now, that's not all of them, but the highest majority are them. And most of the population in this state are up in Northern Virginia, along the beach, or in Richmond. So statistically speaking, most people, you may not be as far away as Red Onion, but it's very common that you are going to be incarcerated very far away from your support network and from anyone else who's trying to interact with you. And to put a personal note on that, this is from an article from a couple of years ago, someone talking about how much money it costs them to go visit their loved one in Red Onion. One more note on the kind of trauma aspect of going in on visitations. Thankfully, they did stop doing this, but it wasn't until 2020, after a lot of public outcry, that VDOC stopped strip searching children on their way in. A young girl was strip searched on the way to see her father, who was incarcerated, and that got enough of an outcry to finally get them to stop that practice in 2020. I am not going to go through this in too much length. I wanted to put this in here as a note about what we were speaking about before in terms of extracting money from people who do not have very much. This is, for those of you who can't read the title, it's called Reduction and Elimination of Costs and Fees Charged to Inmates. I don't like that word, but that's the word they use here, of state correctional facilities. This was prepared by a lot of advocates and others working outside, doing advocacy work in the Department of Corrections interest, talking about the cost of phone calls, of commissary, of video calls, of adding money. Like, we all think about transferring money or depositing things with Venmo or things like that. In the Department of Corrections, if someone wants to add money to a loved one's commissary account, you add $25, you're charged a $6 fee. Rates that would be considered absurd outside the prison or maybe the payday loan industries. And so I'm not going to go through all these, but I do think if anyone's curious, I can show you where this report is. I think it's really interesting to go through all the different ways. And again, I think, as Professor Collins noted before, giving us the intro on the prisons aspect here, that there is no market competition here. There are basically two companies that control all the electronic messaging in and out of the prisons. They basically agree to you sign contracts, exclusive contracts with the state. So the state may have the ability a little bit to negotiate around who they're using, but people who are in the states, who are being held by the state, have no options. You either pay these fees or you don't get to communicate with your loved ones. And even when you pay these fees, including for the phone calls, for anything else, they're still not private. None of this is going to be private. So the emails you're sending, are all going to be monitorable. Okay, so I don't really have a good answer. Comes to this as I am still, I think, struggling with this as, anyone would be, and this is part of what got me interested in this. I do think, though, that we have a duty here, and I wanted to use a quote from Professor Seema Saifi, who is at Rutgers University and writes a lot on this issue. And her quote is that, due to the systemic operation of mass incarceration in this nation, people in prison have insight on what is happening on the outside by the aggregated phenomena they observe on the inside. And reimagining the ambitious project of reducing prison populations demands a reorientation towards co-generating ideas alongside people banished from our polity. And so I think there's two aspects to that aspect there, too. One would be that, again, I think going back to the movement and community lawyering aspect here, is that we have a kind of obligation to avoid especially I think in the prison context, the paternalistic past of lawyers going and saying, we see this problem, so we're going to sue over it, and this is our biggest, we're helping you. We're I think, especially in the prison context, you have a lot of view of prisoners as people to either be pitied or saved, as opposed to worked alongside or worked with. And that is a big one here. And I think that lawyers have I think that we have a duty to do this because I think it's very hard to imagine that the current mass incarceration system would exist absent lawyers, up and down the scale. Most of the people graduating from any law school will at some point involved in legislation, criminal defense of some point, judicial aspects, all of these things that lead to this. I think we have a duty to also try to undo the harm that we as society, as we as a profession, have partially been responsible for. But also because we have a unique privilege in the prison context. Basically, everything that I just spoke about before, in theory, does not apply to lawyers. When you have if I have a client who's placed in solitary confinement, now whether or not this actually happens is something a different story, but by law, I am supposed to still be allowed to speak with them. Their visitation rights are taken away. They can't stop me from visiting them. They cannot monitor our phone calls. Now, they can monitor the JPay emails because that's owned by a private company, but that's a separate thing, so you don't use those. But there are also, I didn't bring it up before, but there are limitations in how much mail you can send. It goes all to a central location, it's scanned, and then sent over. You are limited to 6 pages scanned, so front and back, so 3 pages really, and that includes the envelope. Maybe it's 4 and includes the envelope, so you really get 3. Again, I'm not bound by that with my clients. And so I think that one of the things is that we just have an obligation to be basically messengers, or informational conduits is the other phrase I've heard used. And I think that that's really important that we have a duty to do that because we have this connection and the ability to speak with them. Also, though, I think going to the second point of Professor Saife's insight is that people in prison know a lot about what's happening to them and what is going to be able to, so both in like a law-specific litigation aspect, I think that, and in like a kind of general social movements aspect. And along that line, I wanted to tell two short examples showing, or stories about that, one from New York from about 20 years ago and one from my own practice, depending on how much time we have. I want to say before I get into this story that most of the facts come from an article that Professor Saife wrote, and as well a doctoral thesis that Orasamni Burton wrote from UNC. I just want to make sure I credit them for that. Okay, so up here we have Larry White and Eddie Ellis. These guys both deserve their own books. They have had books written about them. I would encourage you to go look them up, but I'm going to give kind of a short history of what's important here. In the 70s, these two met in Green Haven, New York, where they were incarcerated together. They had both been moved around the New York State prison system after the Attica uprisings in the earlier 70s. And at Green Haven, Larry, who had been there for a while, had formed what he called a think tank. He had been an intellectual, a leader in his community outside of the prison, and was trying to involve a lot of the same organizing and talking techniques behind the wall as well. And with Eddie, one of the things that they discussed a lot, and the whole group of them, there were about 6 to 9 fluctuating over the years as they were transferred around, they talked about the fact that basically that the prisons were in furtherance on furtherance. They were another aspect of their community. That they saw the same communities they had seen in inner city they were both from Brooklyn themselves, but from New York City as a whole, repurposed in the prisons. And the way, what they mean by that is that they saw a lot of the same people and the same problems. And so they would talk about, Eddie would say that one of the things they talk about in the oral interviews done with them, oral histories after they were both released, is, every person who came into the prison they knew, or they would know someone else who knew them. They're all from the same areas. And I think this is kind of seen as accepted now, but these two are basically credited by many people with first kind of articulating the idea of what's now called the $1 million blocks, if anyone's heard of that. And so I'll get to that. What they did is they realized through internal communication, and then through kind of like informal censuses they passed around, trying to figure out where the other people in their cell blocks were from. And they realized a lot of them were from the same neighborhoods in New York. And over a couple of years of doing these informal censuses, passing them around the different state prisons, talking to other people, at that point especially, I think was helpful to them. New York was, as a way of dealing with the uprisings from Attica, they were transferring people all the time, but that also meant that they had a constant change of people going through near them. And so they kept asking more and more people where you were from. And eventually they got enough information to get an outside group, a black-led group, to help them from New York to basically compare data. They took the New York census, the information from that time, it was in 1977, I believe. They had the New York State, their best guess, whatever the last census would have been, so that's 70, and the information for the Department of Corrections and where everyone who was currently incarcerated in New York. And they found out that and I'll show you what those are for a minute, that 75% of the people currently incarcerated in New York when they did this in 1980 were from 7 neighborhoods in New York, or 17 assembly districts, if anyone's familiar with that. So basically, and that's where the $1 million block idea came from, is there were blocks in New York City where the Department of Corrections was spending more than $1 million on incarcerating just people from that block. And I think importantly as well, they also realized that, the ideas they had from before that is that they released a kind of not just these numbers, but policy prescriptions for that as well. And I think where this became important is the idea that we're spending $1 million on correction. And again, many people credit them with the idea, or in this context, of popularizing more so the invest, divest idea in this context, that $1 million, not only are we spending $1 million on corrections for that block, but that all those men were able to talk about how poor their schools were, the other neighborhood help that was going on, that these communities the state is willing to spend millions of dollars on incarcerating these people, but not on providing any kind of social services. Or any kind of aspect to and so that is something that became very well discussed. like many things you can see, you kind of can see that's the best cover I could get. Their article was their study they released was not well published at first, but in the early 90s, and I couldn't quite find out why, the New York Times picked it up and kind of reran the numbers with some help from other people and published front page news in the New York Times, and it's still gone on now. The photo on the right is from the last census data. That's from Columbia University, and that is Brooklyn. And as you can see, you basically still have $1 million blocks. You can see that there are blocks where close to half of the block is incarcerated, and areas where there's almost no incarceration. And so one more thing I wanted to say on a quick story on that line. The other aspect of this, I think, is that for those of us who do, for anyone else who does more traditional prison litigation as well, is that we're taught a certain way of thinking in law school. I think for better or worse in many aspects, we are taught a very narrow way of thinking, and that I've found that people who are incarcerated, who read a lot of law, oftentimes the law library is one of the only things they're allowed unfettered access to, especially during the pandemic. I wouldn't say unfettered access, some access to, can have much more inventive ideas about things that would, because they come from outside the kind of basic system that we often think about. And the one really quick example that I wanted to give from my own practice, I do some compassionate release federal resentencing work. And one of the issues that came up recently in a case is basically there's a rule from the sentencing guidelines that you get eligible for certain relief if you serve 10 years, or there's discretionary after a certain 10 years. And I was talking about that with my client because that had been a recent change after I had been speaking to him, and he has not served calendar years, 10 years. And him and I are talking about it, and he, and so we hang up, I tell him about that, he's, it's upsetting, but there's not much I thought we could do about it. Hear from him again the next week, he was talking about the other guys he's incarcerated with, and they were like, well, when we talk about how much time we've served, we all basically calculate it based on when we're going to be released. So talking about good time credits again before, if you and the client I'm dealing with is someone who has had no disciplinary infractions within the prison, he's somehow, I've actually it's pretty impressive over like an 8-year period. I've never seen that before. And, he's saying that since, of my sentence, counting in the good time credits, I've served then about 10 and a half years of the 14 years I will eventually serve, because I will only serve like 12 years and 1 month of real time. And so basically he was saying that, I count, and the Bureau of Prisons to me seems to be counting, how much time I've served to include the credits I've earned. And that's something that I don't think I ever would have thought of. And I think and it's funny, I talked to a public defender here about it, who at first went like this, and then we talked about it more, and that is now part of my argument, and I'm arguing it at the Fourth Circuit in a few months. So we will see if that goes anywhere. But I think that I think that that's all something to point out that, and so going back to the previous slide, there we go. I think that the last one is really important also, is that I think that a lot of us, it's not just having more interaction with people who are behind bars, but taking seriously the things that they bring up and talk about. I think that that there's a lot of information that comes from both in the technical legal aspect, but also going back to Eddie and Larry about the more social movement building, that those who are directly impacted by all these systems often have the best ideas about either ways to fix it or what the real root cause of that impacting is. I think it's very easy to think about an imprisonment as I think part of what they were talking about was that, society had failed them far before they were actually imprisoned. Is that, this idea is that we think about the horror, the worst part of imprisonment as the extraction itself, but they were saying that it's just another continuation of what we've been doing to them their whole lives to a certain extent, that the prison was just the next step in the failure to provide social services. So that was a lot. I'm at about 45 minutes here, so I think if anyone has any questions, I'm happy to try to answer them.
Hi. So to clarify, I also am not a huge fan of prisons. Mm-hmm. I don't like prisons, but the Department of Corrections was one of the first paid 1L jobs that was offered my 1L year. So I did work for the VDOC for about a year and actually answered some of those disciplinary appeals and tried to be subversive and find loopholes to throw the charges out when I could, as one does. But through that experience, I also was disappointed but not surprised at how much the department could hide the ball, especially for lawyers litigating these kind of claims for their clients, and basically statutorily not having to give any information if it can fit into a super broad exception. So my question would be how you litigate around those exceptions and how you counsel your client through that, I'm sure they already know that the department tends to do those things, but how you counsel them through that process.
Yeah, it's a few things. I think I'll take the counseling part first on that. I think, in my experience, they usually already know better than me. I think a lot of people, people, especially who've been incarcerated in state prison for a while, are often more familiar with the rules and regulations governing, the state or the regulations than I am. But if not, I just try to, I think counsel them through it the way, I'm a big fan of trying to speak to people like a human and saying, that look, this is, frankly, really shitty, and that we're not, this is going to be a problem, but that this is the state of what this is currently, and we're going to try to work, I will do my best, and then go into the next part about how we try to get around those. And that, I think, very much depends on what type of litigation you're looking at doing. I think what you're referring to is the FOIA laws here. FOIA, there's pretty massive exceptions for the Department of Corrections that they don't really have to give you pretty much anything under FOIA. And so I think that, there's two aspects to that. One is that there is one overriding thing on that, which is HIPAA. Anything involving the individual's medical care, HIPAA overrides the state's FOIA thing. DOC follows that finally, and so I think that's one aspect, is getting medical care. The other thing is that you have to try to, that's where I think I try to use the pleading to get more technical, the pleading to your advantage, is that, if I write a complaint and say this is what, my client said happened, what the people around them said happened, oh, by the way, I asked the Department of Corrections for their view, they refused to give it to me, and I filed that complaint, and it turns out, that's where the one nice thing about the kind of pleading standards here is I basically, I trust the people that are telling me, and I kind of put it in the Department of Corrections bucket that most of those exemptions are discretionary. So they have the authority to give me the information. This isn't like a HIPAA thing where they aren't allowed to give it to me. They're choosing not to. And so if it's something where I think that, we're pretty sure there is a case there already, we will basically call them on that and put that in front of the judge. And then later, if it turns out they have some documents showing something, the judge will be more mad at them for not giving it to me earlier. And I do actually find that in my practice too, that they always give me things if they think it shows they didn't do anything wrong. And so actually when there isn't something, it's usually more telling.
I'm a public defender here at the City of Richmond. Appreciate all your statistics. I have a friend, George Hawkins. He's currently suing Governor Youngkin for when he was in DOC. He did not get adequate dental care and lost all of his teeth, and he's struggled to find lawyers who will help him in pursuing his claim. How do we educate the legal community? I think there's presumptions that, they're getting their basic human rights met. And could you touch on just the difficulties of getting medical care when someone is incarcerated?
Yeah, absolutely. So first I want to say that in the next panel, maybe Anna, who's currently one of the lead lawyers on a class action involving DOC's lack of medical care, might be able to talk a little more about that. But yeah, there's the difficulty in informing medical care is that, again, these same guards are your access to care. Everything goes through them. So for instance, if you are in a cell, you cannot walk over to someone for care. You have to request care from someone else. If your complaint is pain, you will basically be told you're just asking for drugs. And so things of pain often don't get there. You have to pay copays in many instances. You are given supposedly constitutionally adequate care, but you still have to pay copays, and almost in the Department of Corrections facilities, they're actually much higher in many regional jails. And I think that, the other thing about the healthcare is that it's still, it's money, and they can get away much more. To back up one thing, prisons are immune from negligence, medical negligence. And so and they very much know that. And so the medical standards, I think, allow them to basically, the standard that they try to meet is just negligent. And so trying to think there's so much of why it's hard to access. I think the main reason it's hard to access is I think people don't take their complaints seriously or see them. I think there's like a cultural aspect of that. But there's also the monetary aspects that, so for instance, at most of the prisons, you have maybe one doctor, and then everyone else is going to be usually a licensed professional nurse, maybe one RN. There's very rarely staff, on call other than a few of the prisons overnight. And so you end up with people who have emergency care. The prison either spends a lot of money to send them to a local hospital or just tries to ignore it. And they have different attitudes on those. And I guess the last thing I would say on that, I don't know if it's a cogent answer, but the other way I think I know that the lack of medical care is really hard to get there is that in the 5 years I've been doing this, I'm personally aware of 24 deaths, and that's not the ones that I'm not aware of. A couple, I think 100 or so hospitalizations, some of the same people, and so I think that the numbers bear out that as well. But yeah.
Hi, thanks for being here today. You mentioned briefly the new ombudsman position that I think was made statutorily a year ago now, or even
3 months.
It was just this last cycle. Okay, so it's pretty new still, but I was wondering if you have any sense of how it's going to affect your work, if at all, or make things more transparent in the VDOC system. Just what you're looking forward to, or where you think we might want to pay attention to what that position really does.
Yeah, I mean, I'm not too optimistic, to be blunt, on that. I think, one, they haven't filled that position yet, so it's been statutorily authorized, but it has not been filled. But the other thing, I think that the main thing I'm looking to see out of there is numbers. Like I was saying before, a lot of this we have is they're not required to keep numbers and produce numbers, and you'll see like the reason why so much research on prisons is at the federal level, because the Bureau of Prisons does have much more minute and information gathering systems. They're not true in Virginia. So the main thing I think is that because of some of the reports that they're going to have to make to the ombudsman and things like that, that we might have a better idea of some numbers of things. Like, for instance, they finally made them last year start keeping track of how many dog attacks there were. So there were no lists before that, and so now and again, there's nothing stopping them. But at least we now have some numbers. And my hope a little bit is that, from a political process point of view, I don't really see that position having any material effects on its own, but that the numbers or the information that comes out of it, or maybe the individual stories that are told through that, could have some kind of impact at a legislative level. Because I do think that it's, one of the biggest things is, I forget your name, but what the public defender asked before, is that there is a big societal disconnect between what people think happens behind prisons and what kind of rights and, things people have behind prisons and what, it reminds me a little bit of all the news recently about the supposedly great situation for, asylum seekers here and things like that. Like, people have this very incorrect view of how, easy or something like it. And I think that, to a certain extent, getting people to realize, and numbers are sometimes more impactful to people than individual stories. So.
Sure. Thank you for this. This is very informative and helpful. So I want to ask about the labor story in this scenario. How is labor experienced by people like in prison system? Is it a form of punishment, a form of reward? How do they like it? Do they want it to do more, do less, be compensated, not compensated, all those things?
So I think I don't have I can answer from the individual people that I've spoken to. I think that most of the ones I've spoken to do want to work. The most common thing I've heard of is that even at its best, prison is incredibly boring. And so having a job, something to do, you often have more individual freedom at that point. And you will see that in Virginia, often you have to be a lower security levels, because so they consider it as well something that you must work toward. And so you do have this weird disparity where the people do seem interested in doing this because it is better for them. But I think at the same time, some of I've spoken to also know there's an understanding that they're being exploited at the same time. That like, this is still better for me than the alternative. But also, I think the other thing is I struggle to call it work to a certain extent as well, because it's not really voluntary. As in, once you sign up, you often cannot unsign up. So like, if you say I'm going to the job and you don't show up, you can be punished for that. And there's also, again, there's no OSHA doesn't exist. There's no like those kind of, so in addition to not being able to be paid, it can be you have people doing jobs that they maybe weren't trained for. They're very dangerous. But in terms of the individuals that I have spoken to, I still think that all things considered, that is still something they want right now. But many of them, I think that there's one of the biggest things I've heard from people who are more, into organizing or more theory, there is like the fact, I think it's very telling in there, one of the things you hear about the most is that the universities use their equipment. That basically that they, there's all this money going to the very nice University of Virginia and they're using, materials built by people who are currently incarcerated, 30, 40 miles away from them. I think that aspect comes up a lot, but it is one of the questions that I would love to know if we were able to have more. Like, that's one of the kind of things where it'd be great if I could get like 200 people together in a room and have like a round table. And that's just the kind of thing that, absent certain class action aspects, I've never heard of being able to happen in a prison.
All right, we have a question up here in the balcony.
Hi, Danny. We last met on the pickleball courts. But I was curious when you were talking about how there's not a lot of regulatory oversight of prisons. I was curious, one, if that is uniform across the states as far as you know and across the federal scheme, and two, if you're aware of any organizations that are actively pushing for regulatory oversight of prisons and how effective their advocacy has been.
So I am blanking on his name. Professor Aaron something at UCLA's Prison Project wrote a huge law review about this. Someone know his name? Littman, thank you. Wrote a long thing about regulatory law. I think he called it regulatory law in prison, something like that goes through the states. And I believe he was saying, and he goes through those examples. I don't think there's any state that's really trying that as an example of something that he's pushed as an effort. So my best guess would be to look. That article was published a few years ago. I'm not sure if UCLA's, they're like probably the most advanced. I think I would argue that they do the most work of any of the law schools in this context. And so I think that if anything's going on, that would be my best guess, but I'm not personally familiar with it.
Takes a second for the mic to work. I think we have time for one more question. Is there? This is the nice off.
I don't want to lose the time. Do you do any work in federal prisons, and do you see major differences between the federal and state prisons?
Yeah, I do. So in federal prisons, I don't do nearly as much work there because there's only two in Virginia, and they're both, one's pretty small. The biggest difference I see there is, there's just way less law involvement because it's almost impossible to sue for almost anything. That's a separate issue there, but as hard as it is to bring lawsuits in state prisons with the PLRA and other things, excessive force is pretty much immunized between the overturn of Bivens and the Federal Tort Claims Act. If anyone's interested in this stuff more, I could talk about this for a while, but I think that's the biggest difference I see there. And more separately, I think that there's the culture, as I've seen, I think it's true in Virginia too, but I'm more aware of it, it's very dependent on where you are. I mean, the federal prison system is so spread out, so I have I have 3 current federal clients, and while they all started somewhere in Virginia, they're currently in Beaumont, Texas, Big Sandy, which is somewhere in Kentucky, and one of them is in Hazleton, West Virginia. And so, and all these guys, are from the Richmond area, were convicted of things in the Richmond area. And so, in terms of I have 2 of them I've never met in person. I've been their lawyer for about 2.5 years now. And so, it's, I think that's the biggest thing I think there is that there's more, and you will see a lot more, they actually have a term for it, the U.S. Marshals. They call it diesel therapy when people are acting up and they'll send them around the prisons because they use diesel vehicles. And so that's the phrase the Marshals will give. So if it has a nickname, it happens fairly often. The Marshals will just talk, by the way, when you're there. So anything else? All right. Well, thank you so much.
Thank you, everyone. So our next panel is going to begin at about 2 o'clock. So if you'd like to get up, now is the time to stretch your legs and enjoy the last bit of freedom, and then we'll close strong. Thank you very much.
go. Hello, everyone. My name is Hannah Nemenik, and I'm the executive editor of Law Review. We have officially reached our last presentation of the day, so thank you all for being here. Our panel will be discussing ethical considerations of movement lawyering. And just a few logistical notes, as this is our last presentation, we just ask that you remain seated at the conclusion of the Q&A just for a few final reminders and concluding remarks by Alyssa. So without further ado, I will pass it along to our moderator, Professor Samuel Siegel.
I'm Doron Samuel Siegel, a member of the faculty here at the law school, and I'm really honored that the students who are part of Law Review invited me to moderate this panel. I think it's going to be a fabulous way to end the day, and I think the vision for the discussion in this hour is to think about ways that members of the audience might concretize some of the maybe perhaps more abstract or theoretical ideas that have been shared today. And we're hoping to have something to offer to everyone in the room, future lawyers, current practitioners, regardless of whether you are engaged in your day-to-day life as a movement lawyer or community lawyer or organizer. We're hoping that there's something here for everyone. So I'd like to begin by just quickly, very briefly introducing our panelists, and we'll save sort of more in-depth introductions for happening over the course of the questions and answers that we'll have. Again, Doron Samuel Siegel, my pronouns are she, her, and to my left is David Walrod. And David is a public school teacher, he's a special education teacher, and he is the president of the Fairfax County Federation of Teachers, and his pronouns are he, him. To David's left is Anna Kurian, she, her pronouns. Anna is at the Legal Aid Justice Center, and she's the legal director of the Civil Rights and Racial Justice Program. And finally, the third member of the panel is Cassie Powell, my colleague here on the faculty at Richmond. Her pronouns are she, her, and Cassie is the inaugural director of the University of Richmond School of Law's Access to Justice Clinic. So with that, I'd like to go ahead and begin with a first question for the panelists, and perhaps I can ask, let's see, why don't I ask Cassie to start, and then we'll come down the road toward me. I want to ask you to talk for a moment about your current work and what your goals are, what your day-to-day work generally entails, and if sort of relevant, maybe share a little bit about the organization where you work, although for Cassie, I guess that's a little less relevant. So Cassie, take it away.
Yeah, thank you so much. I'm really honored to be able to be here and really appreciate being invited to speak and all the work that the Law Review and Alyssa has done putting together the symposium. I think it's most useful to approach this question from my historic work and what I've done in the past and what I bring to this position since I just started as a faculty member. So I was a legal aid attorney for 7 years, and what's most relevant, I think, to this panel is I practiced community lawyering in a variety of different ways and a variety of different issue areas. And so some of the things that I did was coalition building around school funding issues and impact litigation around school funding when I was an attorney at the Legal Aid Justice Center. And then I really fell in love with that work. I fell in love with the particularly the community-directed portion of community lawyering work, and we're going to talk about the definitions of movement lawyering and community lawyering. But that was something that I really fell in love with, and I brought that to my next position, which was a legal aid that provided mostly direct individualized representation to folks in a variety of different areas. And so what I did when I went to a new legal aid as a managing attorney was I brought sort of community lawyering to that work, particularly around housing justice. And so, for example, that looked like helping tenants who were experiencing illegal or abusive practices by their landlord form tenant associations and understand their right to form tenant associations. And that's something actually that I've been really excited to be able to bring to my work in the clinic as the director of the new Access to Justice Clinic. So we're doing individualized cases, we're doing individual representation in housing cases, and a variety of other issue areas. But one thing that we have been doing is we've been able to partner with a local legal services organization to respond to some illegal practices from in a housing community in Richmond. And so this is something that I'm really passionate about. I'm very grateful and excited that so many students that I've been working with in the clinic and at Richmond Law are so excited about community lawyering and social justice work, particularly in that type of way. And so I'm looking at one of them now. And so that's been something that's really wonderful. So I'm excited to be able to continue that practice work in the clinic.
Hi, everybody. Good afternoon. Thank you to Alyssa and everyone who's put forward the symposium. I've had so much fun here learning, which is a thing that feels like a luxury in day-to-day work. I work at the Legal Aid Justice Center. It is a statewide legal aid in Virginia, and there are 6 main program areas that we have: immigrant justice, youth justice, housing, consumer justice, health, and then I'm the program director for our civil rights and racial justice program, confusingly named, but it is our criminal legal work, and we are looking at systemic responses and solutions to low-income Virginians who are enmeshed in the criminal legal system. And one of my colleagues is here, and a former colleague is here, but I feel really grateful to do this work every day in partnership with smart, committed, and talented people. And so when you think about the criminal legal system in Virginia, unlike our other programs at LAJC, where there's a big component for individual representation, because public defenders do that already, we have the luxury on sort of focusing on the longer-term systemic advocacy work. And so if you think about the criminal legal system as a train, part of what we're trying to do is intervene at every point. So at the beginning, we have our building community safety work, so that's working on police accountability and making sure that people are prevented from getting enmeshed in the system in the first place. Some of that work is mutual aid, and then we're also working against the expansion of the jail in Charlottesville. And as you heard earlier, there was a big prison boom in the sort of 60s and 70s, and so if you think about all of those institutions, they're all getting old now, right? So across the country, you're seeing people saying, we should have compassionate jails, we should put more money in, and so this fight is not just happening in Charlottesville, it's sort of everywhere, and we're perfectly poised temporally to have this conversation. So that's our sort of, one of our campaigns. Our second campaign is on pretrial justice. So if you think about where people are getting into the criminal legal system, Maisie, my colleague here, heads up that work, and it is looking at access to counsel at first appearance, presumptions against bail, failures to appear, everything that happens at the beginning of the system. Then if you get further into the criminal legal system, we have our fines and fees work. So we're stopping really our big, being a legal aid and working with people in the criminal legal system, fines and fees is a big part of what we do and see as a pretty big strategic priority. One big victory we had before I got to LAJC was stopping the practice of driver's licenses getting suspended due to criminal court debt. Now we're looking at the issue of public defense fees, a huge issue in Virginia. We have a wonderful report about it. Please read about it, get enraged about it. What is the Sixth Amendment if we keep doing this? And then we have our expungement and record sealing work, and then we have a class action. So that's sort of all of the points in which we try to intervene. I feel very lucky to do this at LAJC, and I've been here for 3 years now.
Hi, my name is David Walrod, and I'm a special education teacher with Fairfax County Public Schools. I've been on leave for the past couple years serving as president of the Fairfax County Federation of Teachers, which is one of the 2 teachers unions up there in Fairfax County. Just to give a little bit of background on some of the work that we've been doing recently, collective bargaining in the public sector was banned in Virginia by the Virginia Supreme Court back in 1977. In 1992, I believe it was, the General Assembly passed a law formally banning collective bargaining, and that law was signed by Governor Wilder at the time. Back in 2019, we started making a really big push to try to have that ban on collective bargaining in the public sector overturned, and Governor Northam signed a law formally overturning the ban and allowing collective bargaining in the public sector back in 2020, delaying implementation for a year until 2021. The way that the bill was written, each locality had the option of whether or not to engage in the collective bargaining process. And over the past couple years, myself, along with my counterpart at the Fairfax Education Association, have been working on building an alliance trying to build towards collective bargaining in Fairfax County. Together with my counterparts at the Fairfax Education Association, we were able to get Fairfax County to pass a resolution formally allowing collective bargaining this March. We then actually began the process of collecting signatures and began the process of building towards holding a union election. And that election happened just a couple months ago, back in June. That was actually the largest election in the public sector since 1999. We were able to bring collective bargaining rights to 27,500 people. And fingers crossed, knock on wood, on Wednesday, a couple days from now, we are going to actually have a tentative agreement on a first collective bargaining contract for all teachers and operational staff within Fairfax County. So that's how I've spent my summer vacation since last time I was in the classroom.
Thanks, David. Cassie alluded to this earlier. We'd like to just talk about some definitions. So perhaps each of you, as relevant to the work that you do, could share definitions of movement lawyering, community lawyering, and/or organizing. Maybe Anna, start with you, and then we'll go to David and Cassie.
Sure. I really came to community lawyering by accident. I started as a public defender in Atlanta, Georgia. I did that for about 11 years, and I represented people charged with felony crimes in state court. And part of what I saw was it was the state of Georgia versus my client, right? There was a whole bunch of people on this side and one person on this side. And to me, I think isolation and powerlessness are sort of hallmarks of how labor, liberation, dignity is extracted, right, from poor people, particularly in the United States through the Carceral State. And it struck me because I, would go and talk to all the friends and family of my loved ones. There were a lot of people on this side, right? It was not a lot of people versus one person. It was a bunch of people in power. Sometimes the victims agreed with a carceral solution, but when they weren't, they were disposable. And then there are a whole bunch of people on this side. And so to me, I would go to my clients' families and friends, and I would bring people into the courtroom to show the judge. 20 people would stand up and say, I want this person released, right? And the joke was always like, oh, this must be one of Miss Korean's cases, because the courtroom is packed. And I think for me, having all of those people come together, they were also able to look at each other and say, gosh, we're powerful. We're all here together. And I think that was, for me, a way to shift the balance of power in the courtroom, because as a public defender, you have very little power. And I realized that actually I had a lot. There were just a lot of people thought of as disposable by the state. And so I started this practice of participatory defense, which lots of people across the United States do, and it was popularized by Silicon Valley Debug, which is a really great organization in Silicon Valley, and they do things like making social biography videos, right? So they would go and get to know someone's life and make a video about that person's life. Why? Because you have a grandmother who is extremely, verbose and colorful and tells amazing stories about her grandson, but she comes to court, a judge is seated on a podium pretty high up, and she gets nervous and says, please let my grandkid out. But if you go to where someone is and you are sitting in their living room and you ask for stories about their kid or their family member or their loved one, people actually feel empowered to share, and you can make a home video, which I did. I have no video skills at all, but the idea was really to sort of leverage who my client was and who this human being was outside of that one moment. Because what the criminal legal system does is it starts the story at a very particular point, right? And it obfuscates the violence, the systemic violence that has preceded that moment. And so really, I think a lot of public defense is just sort of zooming out. And so for me, movement lawyering, community lawyering has just meant having a more expansive definition of who the state is harming and bringing all of those people's voices in. And so I started a community organization in my spare time from being a public defender with some friends and clients called Building Locally to Organize for Community Safety, called Blocks. And so we were really focused on community safety and having it be local. And we did things that I think were fairly, went to city council, showed up, talked about safety being more than policing in prisons, and really made sure that poor people of color in Atlanta had their voices included in that. For a civilian review board, which back then was a pretty radical concept, I think that has changed, thankfully, and so that's how I came to community lawyering, and I feel really fortunate at LAJC to have sort of what I did in my 9-to-5 and what I did outside my 9-to-5 all come together in one place.
I really love that, especially, again, to me, what I love most about this work is the fact that it is community directed. It's directed by people who are most affected and impacted by the issues that we're working on. And that's something that I didn't necessarily learn as a law student. I knew I wanted to do anti-poverty work. I knew I wanted to do social justice work, but I didn't know exactly what that would look like. I did individual representation as a legal aid attorney, and then learned about community lawyering when I went to the Legal Aid Justice Center from several wonderful people in this room. And so, to me, community lawyering and movement lawyering, I use them kind of interchangeably, although I have lots of views on the different ways in which they are used, and if you take my class, you will hear about them. But I do think that there's ways to do movement lawyering that is not directly led by the people who are directly impacted by the issues that you're working on. For example, if you are a group of lawyers in a room and you're building a case and you're thinking about the issue that you want to work on, and there's no one who's actually directly impacted by the issue in the room with you as you're building the case, and then you're like, I have to find a plaintiff who meets this particular set of issues. I'm not sure that that's community directed. There may be ways in which that is important work that is serving a very important policy goal, a very important social justice goal. But to me, the way that I've always tried to work as once I started this practice, this type of practice, is to be focused more on community-directed work. And so to me, I define community lawyering as lawyering that shifts the balance of power from attorneys for me and to the people that I'm working with. So, for example, if I'm supporting a group of tenants and forming a tenant association, I am providing community education and I am providing support to them so that they can understand and make their own decisions about risks and rewards and benefits, and really be proactive in developing strategies for what they want to do next, whether that's litigation against the landlord, whether that's some sort of collective advocacy action, but some sort of thing where they are actual real partners in the process of strategy. And I think that that's a little bit different from the type of lawyering that we learn in law school. And that's to me what it means.
So when I think of organizing, I think back to the way that I got started with the union, and this is the way that a lot of people get started with the union, is realizing that there's a problem somewhere and knowing that it needed to be fixed. When I think about organizing, well, just to kind of explain, if you get a group of teachers together, they're gonna all start complaining. It's what they do. They're gonna talk about how they don't like this, they don't like this, they don't like that, they think that this should be different. Organizing is going from complaining to saying, well, so what? So what are you going to do about it? Complaining, you're just sitting there, this isn't right, this isn't fair, I don't like this. So what are you going to do about it? And in my role as union president, what are you going to do about it? You're going to get 27,000 people there saying we need some changes, we need it now, and here's how we're going to make those changes happen. And so that has been one of the really exciting things that I've been able to see recently. And what I've really found as a union leader, leaders a lot of times just come about because somebody asks them, what do you think about this? Is this something that you're really willing to fight for? And it's the people that say yes. And if you say yes one too many times, you find yourself president of the whole thing. But that's a different story. The key thing, though, is whenever you're talking about organizing, you're thinking, you have all of these things that you want to fix, so what are you and your colleagues going to do to make it better? What are you and your colleagues going to do to fix it?
Thank you all. I think that ethics, which is the sort of central procedural, I suppose, sort of organizing principle of this particular hour, ethics is invoked by all of what we've talked about already, thinking about our identities as lawyers and actors in a community, the relationships between what we do and what we're trying to achieve. But now I want to ask a question that has the word ethics in it. So I think I'd like to ask Cassie to answer this first, and then proceed with Anna and perhaps David on the subject of ethical considerations and accountability. So as you think about your services, the services that you've provided to clients and communities, could you talk about how you navigate ethical considerations? Maybe you could share an example or a particular story where you faced something particularly challenging, and maybe talk about what was challenging about it, what resources you used to navigate it, and so forth.
Yeah, that's such a good question, and I think that this is a particularly fraught question in movement and community lawyering. So for me, one of the biggest ethical considerations that I have whenever I am doing this type of work is who my client is. Because when you are doing a case, for example, you're representing someone in an eviction, it's very clear who your client is. You're representing the person who's being evicted. If you are working with a group of tenants in a mobile home park, for example, who received an illegal notice from their landlord that their rent is going to go up, and those notices are illegal under the law, is your client then every single person who received the notice, every single person in the neighborhood, everyone who's coming to the tenant association meeting, everyone in the tenant association, or just the president of the tenant association? And these are all very important questions for you as an attorney, because in order to practice and complete all your other ethical duties as an attorney, communicate, define the scope of your representation, be a diligent attorney, you have to actually, one, know who your client is and understand their goals, and then be able to communicate the risks and rewards of all of what you're doing to them. And so that to me is something that's really, that's one of the biggest considerations that I have. And so typically the way this starts in the housing justice context, where I do most of my work now and have for the past 3 years, is, if you have a tenant association, usually what happens is I'm contacted by a local community leader who lives in the neighborhood, lives in the mobile home park, and is like, there's an issue going on in the park. There's something that's happening. Can you come out and talk with tenants? And it's usually pretty amorphous. It's just like this group of tenants, and they want to talk to an attorney. Some of them want to talk about just their individual issues. Some of them want to talk about, we want to take some sort of collective action against the landlord. And so my role in that space, until they actually tell me that they want to take some sort of action, is to provide community education. So I see myself as someone who is sort of kind of, using Danny's phrase, an information conduit. And so I'm providing information. I'm providing them information about anti-retaliation laws that the landlord has to follow, tenant association laws, for example, of the subsidized housing property. And so I'm providing them information. And then once they have that information, if they tell me, okay, now we want to form a tenant association, or we want to take some sort of collective action, at that point we discuss, okay, so what sort of decision-making structure are you going to have to be able to communicate with me what you want to do? And so we, for example, if we're forming a tenant association, we sometimes set up like an executive committee, like a group of 4 people in the park who everyone is like, yes, we trust these people. The people who are in the meeting are like, yes, we trust these people to be able to at least start this process, to be able to make decisions. And then we talk about, all of those different sort of democratic structures that you need in order to proceed. But that can be really hard, and there's often lots of conflicts that come in place. For example, I do a lot of individual representation for the tenants as I'm also working on their collective issues, and so there's potentially conflicts that might come up there. And so we have to be really intentional about every single part of that process. You have to be intentional in terms of what you're communicating, and you have to be intentional in terms of what you're agreeing to do, and also what information you get from them, so that you are avoiding any conflicts. And so that's something that it's a really hard part of this particular practice. We're about to get to this section in my class, and so we're going to talk about all of that. But it's something that I think scares attorneys, because they're like, there's too many ethical concerns here, like we just can't do it. And I actually think that that's wrong. I think there's a lot of ways in which, as long as you are intentional and documenting what you're doing and you're really careful, you can actually do this. You can do this work, you can do it. And so that's something that I've learned and that I'm really excited about talking about. So those are the big ethical concerns that I think come up in this type of work, at least for me. And I could talk about that more, but I will stop.
Thanks, Cassie.
I think in terms of ethical concerns, when I was a public defender, I had a particular ethical dilemma with a client doing participatory defense, had made a video, and it was a murder case, and his whole family, me, everybody involved, thought he should take a plea. He did not want to take the plea and wanted to go to trial, and at some point had told me, I intend to say something different on the stand than what I've told you. And at that point, if someone's telling you, I intend to not tell the truth, then, usually you go to the judge and you say, I want to withdraw. But if you are a public defender, you know there's no one behind you, right? There is nobody else if you withdraw. And so, the way I resolved it with the State Bar was that he was going to testify and he was going to tell his story in narrative form, right? Which in a murder case is sort of a Hail Mary. It is very hard not to be preparing your client for direct testimony. It is very hard not to be preparing your client for cross. And the thing that happened was that he went to trial, told his story, and we got an acquittal on every single charge, which was amazing. And I think for me, it really led me to think of what the role is of a lawyer and who gets to tell whose story and who has power and who is listened to and whose voice is prioritized. And of course, I think in all of these scenarios, our clients are the best narrators of their own lived experience, right? And I think when you're interceding as a lawyer, there are lots of questions of power and why it is that you are in a position to tell someone else's story for them. So that, I feel like, was one particular ethical dilemma for me. But I think in movement lawyering, in Charlottesville, we're working with a community group to stop the expansion of the jail. And several members of our community group have been in the jail themselves or have had loved ones at the jail, right? And so there are lots of people in our community group that actually do think some money being put into the jail is a good idea. It is an old jail. It is terrible. The conditions are pretty deplorable. And so I think, in movement lawyering, there's the question of, are you doing what the community group wants without question? Are you pushing folks to a different outcome? Where are your principles? Where are your organizational values? And we've had to navigate a lot of those in the last year and a half. And we have done a lot of political education. We've talked about reformist reforms, abolitionist reforms. We've read things together. We've really, I think, struggled with questions and come out better for it. Is there total political unity in the community group that we're movement lawyers to? No. Not today. I don't know that there will be, but these are sort of questions that we are committed to walking through together and having generative conflict and tension that stretches and grows all of us as long as we're able to struggle in a principled way and still be in right relationship.
So just to give an example that builds off of Cassie's idea of knowing who the client is, I'd like to share just a quick example of something that happened recently that in my mind, kind of exemplifies this idea of ethical considerations. The actual unit that got collective bargaining in Fairfax County is called the Fairfax Education Unions, which is an alliance between my organization, FCFT, and our partners, FEA. My national organization is the American Federation of Teachers, and there's a national association for FEA as well, NEA. NEA hired a negotiator, somebody that they wanted to run the negotiations, and they were prepared to have a contract with this lawyer that would come in and serve as the lead negotiator. Once he got on the ground, once he had a chance to talk to everybody, he really sat us all down and kind of said who is actually going to be the client here, because what he realized quickly was it wasn't going to work if NEA was the client. It wasn't going to work if FEA was the client. There had to be a way of making sure that it was actually FEU, the group that had collective bargaining, that was the client for that. And that's something that I'm really grateful for, because if he had accepted the job with NEA as the client, if he had accepted it and filled out a contract with just NEA as the client, that would have really left half of the group out of it, and it would have probably made the process untenable.
Thank you all. It just strikes me that in particular for the law students in the audience, these really are sort of the concrete matters that you can run into essentially on day one of practice, but for which law school doesn't necessarily prepare you. So I'm glad you're here in the room. I'm also glad you're here in the room because of the next question I want to ask, which I think continues the theme of ethics. I want to focus on identity and solidarity. So perhaps we can start with Anna here and then go to David and Cassie. The next question I'd like to ask is, how do you think about your identity, and how does that resonate, or how is it implicated in the work that you do day to day?
Yeah, thank you for that question, Daron. I grew up in India. I'm an immigrant. I came to the US when I was 18, and so I had the very odd experience of becoming a person of color at the age of 18, which, you know, there are pros and cons, I would say. And so I think for me, I think of my identity as someone who is a woman, who is brown-skinned, who's Indian, who's queer, and also is in a lot of spaces that are that have a lot of white people and that have a lot of black people. And I think that is, a not nuanced take on what it is to experience life in America, but here it is. And so for me, I think becoming South Asian in America, which has been its own journey, I feel very committed to not being the kind of South Asian that is propping up white supremacy and that is allied in the struggle to resist anti-blackness, which is pervasive across all racial groups and particularly across class identities. And I think, middle class, South Asian in the US, there are lots of ways that showing up consistently amongst my people and in my community and being very clear where it is that I'm allied with, where my values are, and where I see my social justice spirit being is sort of internal work that is separate from the external work, right? And I just, I feel really that very privileged to do this work and also be primarily in my lawyering roles with communities of black people that are really menaced by the criminal legal system in America. And I would just say that all of us are impacted by difference, right? And all of us are thinking about identity, even if we share a dominant identity. I don't think that we are ever unaware of where we are located. And so I think walking into a room and what group you find yourself in and who you're having lunch with and who you're talking to. And, I think that if you walk up to lots of groups of people that share your class identity, it's perfectly fine to say, what do you do for work? And I think that if you don't, then you really have to be creative about the kinds of conversations you're having. And so for me, I think this work has been a joy and a privilege just because I did not see my life going this way. And I feel like it is very important to me personally to be allied in this fight exactly where I am.
So education is a very pink-collar profession. There are quite a bit more females than there are males. Until you get to administration, at which point it flips and men become more dominant. One thing that you also see pretty consistently is that education is a very heavily white profession until you're talking about support staff that traditionally make significantly less than teachers do. And so those are definitely a lot of things that I see a lot of, especially in my current role. And one aspect that I've definitely seen where gender comes into play is that a lot of the teachers in our buildings tend to be younger. You tend to have a lot of folks that are either starting families or are thinking of starting families. And that nurturing spirit that a lot of our folks have has a way of getting weaponized against our teachers, where a lot of times our teachers are asked to do things that, take away from their time at home, that take away from their own time because you need to do it for the kids. That's a phrase that I never want to hear ever again. But I think those are some things that I see so much in the work that I'm doing right now, just gender kind of getting weaponized. Like, wouldn't you want somebody doing this for your own child? And how do you say no to that question? But at the same time, folks just have to understand that, sometimes you just have to say no. And that's one of the good parts about being part of a union is that they don't have to say no alone. So.
Yeah, I think for me, it's just really important for me to be very aware of my own identity and what I bring to whatever space that I am in. So, for example, if I'm when I'm in tenant association meetings, I'm often the only white person there. I'm often the only attorney there, and I think that it clarifies for me the importance of power shifting and the reasons why it's so important for me and why I believe in this work so much, to shift the power, not only the privilege that comes with being an attorney, but the privilege that comes with being a white person, and shifting that and trying to, as much as possible, shift that power to the tenants and the communities that I'm working within. And so I think I just try to be really aware of the identities that I bring and how that impacts both perceptions of me and also my perceptions of what's going on. And I think that you can't really do this work unless you have that awareness, both internally and externally.
I want to ask another question and then pause for questions from the audience. I have other questions prepared in case you're in a quiet mood, but I just wanted to give you a heads up that the microphone will be available soon for you to ask questions. I want to ask a question about solidarity, and maybe David can start on this one. How do you see the role of solidarity in your work, and what strategies have you used to foster it within the movement that you lead, support?
So solidarity is the idea that nobody in my district listens to me because I'm a special education teacher. Nobody in my district listens to me because of the work that I do on a day-to-day basis in my classroom. They listen to me because of thousands of members that I have behind me. They listen to me because I'm president of a bargaining unit that has 27,000 members. Solidarity, it's really easy to ignore one person. It's really easy to dismiss one person. It's really easy to say, okay, I've heard you, now let me hear the next person that might say something that I like better. It's a lot harder to dismiss 3,000 people. It's a lot harder to dismiss 27,000 people. Solidarity is just that idea that one voice is one voice, but 27,000 voices has a lot more power.
Yeah. I want to actually touch on something that you said, Anna, about just how sometimes there's disunity in this work. And that's something that is really apparent to me in doing this work, is that, it's not like everyone just has the same goal, especially when you're doing sort of broad-scale movement work and you're doing coalition building, which I did when I was at LAJC before. There's a lot of different interests, there's a lot of different egos, there's a lot of different perspectives in the room about what needs to happen and what should happen. And so what I have found is that I really love working with organizers. I think it's very hard to do this work if you don't have organizers. And so some of the strategies that they have taught me about how to bring people together, how to support folks in that solidarity work, that's been something that's really been really critical for me and something that I've learned a lot through. And so I really appreciate doing this work with organizers in particular. And so even the tenant association work, if there's an organizer present who's supporting on that, then that's something that's really, it makes a really big difference and further supports that solidarity work. And I think it makes your work as an attorney so much easier because you have someone who's doing that solidarity work, and then you can come in with the legal support and helping strategize, helping provide information. But I have been in a role of trying to do both at the same time, and that's really hard to do, of trying to do that organizing solidarity work while also being the attorney. And I think that it creates conflicts, it creates some issues, and so having an organizer present, I think, is really important for that work.
Yeah, I think for me, solidarity means bearing witness to people's lives and stories that are not dominant. And it means sitting with someone's pain, sitting with someone's powerlessness, and sitting with someone's lack of hope and hurt and confusion. And ideally, with your legal skills, your organizing skills, you're able to do something about it. But at minimum, I think solidarity means showing up and sitting with people and bearing witness to stories and lives that I think are not celebrated or seen, and where there is a lot of pain and hurt. And so for me, I feel very committed to doing that with my life, even if things can't get better, that I'm sitting with someone in that moment of isolation and trauma, and I'm there and I say, I see you, and I'm showing up every day to do that.
Thank you all. Is it a good time, Alyssa, for questions? Let's see. Are there questions from the audience? Here's Monica right here in the front.
I can project again, or I'll hold this. Really just piggybacking on exactly what was just mentioned, how do you balance the... So I find in interpersonal relationships, sometimes people are more solutions-oriented and some people are going to bear witness. How do you balance your responsibility as union president or an attorney in a space and being someone who maybe is responsible for finding solutions or moving action forward, with also making sure not to center your own work in the movements that you are in? And that could go to all three of you, any combination. Thank you.
I mean, that's such a good life question, right? Yeah, I think for me, it's by simply asking, what would you like to do about this? And I think that I am also very solutions-oriented. I think that is a particular thing that happens to people who want to do social justice work. But I think pausing and asking, what do you want to do about it? Because I think very often I have assumed someone wants to do something about this, and I've also assumed I know what that thing is, and I am 10 steps down that road. And so just pausing and saying, what do you want to do about it, and how can I help, has helped me sort of, I think most often at work, I found that people do want to do something about it, but people have gone down a route that I would have not imagined. So it's just asking.
I agree with all of that. I find when people call my office, sometimes they just want to vent, and after they've had a chance to vent, once they've got it out of their system, they kind of consider the issue dropped after that. But then other times, they want to see action done. And so the important thing is, just like Anna mentioned, asking, so what do you want to see done about this? What would you see as the ideal outcome? And then sometimes we have to talk about if what they want to see, if it's realistic or not. And we have to kind of work through some different options. We could do this, we could do this, we could do this. Which of these would you consider to be the best outcome? But really it's figuring out what their issue is, figuring out what their options are, and then figuring out, now that you know what the options are, now that you know what these outcomes could look like, what do you want to do?
Yeah, I really think that community lawyering is an exercise in humility pretty consistently, because I think, I don't know, I will just speak for myself, but I think I'm pretty ambitious. I have ideals, I have things that I want to accomplish, I want to see change in the world, I have all these things, these ideas about the world, and when I am with a group of people who are directly impacted by an issue, I'm like, okay, I think I know, what I think should happen in this instance. And what I hear a lot is that sometimes that's not what people want to do, and that can be really challenging as someone who has these beliefs and thinks that they know the solution but isn't actually impacted by it. And so for me, it's a consistent ongoing challenge and humility to be able to be like, okay, no, we're going to listen to what the people in the room want to do and modify and adapt and be flexible. And even if that means not pursuing the big case but just working on their individual cases, and that can be really challenging too, because you come in with a particular purpose of wanting to do this big thing because this landlord is bad and evil and you want to challenge them, but sometimes that's not what people want to do. And listening and respecting that and respecting their own boundaries and their own capacity to engage in this work, I think that's also something that's really critical. And so yeah, it's an exercise in humility.
I might just quickly add, I think for those of us in the room who've practiced in outside of the public interest sphere, this question is equally relevant to any kind of sort of for-profit work that we might do. I think law school puts us on certain pathways about, well, if the problem is X, then the solution likely will be Y, or the compensation should look like Z. And that exercise in humility, I think, is essential to client-lawyer interactions, even when the lawyer is being paid, and regardless of the width or narrowness of the power differential between the lawyer and the client. So I think it's a great example of something that translates across sectors. I think there was
There are more consequences, though, for not being client-centered if you are in a for-profit profession than if you're in public interest. It is very easy to not be client-centered if you're in public interest. And so it is really your own ethical core that is guiding you most of the time. There is nobody watching. There are no consequences like someone will go to. If you have a client who has social power and capital, they will, tell you very loudly. But if there's a disproportionate amount of power that you have compared to the people you're working with, it is on you to police this, right? And so just different outcomes depending on where you are. Yeah.
Thank you so much for being here. My name is Ethan. I'm a first year here, so I'm a relative novice in this industry. But I did have a question about the ethics of movements lawyering with respect to resource allocation. So I'm familiar generally that litigation is very expensive and that lawyering in general is very expensive as well. What sorts of choices or ethical decision-making that and this question may be more towards Anna and Cassie's purview, but Daniel, you may have some perspective as well on collective bargaining. What sorts of choices you have to make in choosing which clients to handle or represent, which cases to take on?
That's so hard. So speaking as someone who was a managing attorney at a legal aid, we were often faced with the decision of, limited number of attorneys, massive amount of need, constant things coming in all the time. And we would have to make decisions, okay, are we going to do some sort of collective action against this particular landlord or something and potentially not represent hundreds of people in eviction cases, or are we going, that may help, people in this, mobile home park or neighborhood that are not our clients that, could potentially change these practices, or are we going to represent, potentially these hundreds of people in these eviction cases? And because really the time in doing impact litigation is so intensive, so resource intensive, as you mentioned. And so those decisions are really hard to make when you already are so strapped for everything, particularly in legal aid. And so I will say, just to tout pro bono, often if you are one of those ones who are going into private practice, pro bono firms are really wonderful at supporting in impact litigation because they actually have the resources to do it. And so when I was at LAJC, we partnered a lot with larger firms who actually had the resources to do discovery, to do a lot of the work that you need for impact litigation, and that was something that was really critical. And so for those of you who are not going to go the legal aid social justice path, there's still lots of room for that advocacy. So that's something that can be really helpful, but ultimately it's just a very hard decision. And a lot of times what it would come down to for me is how engaged the community that I was working within was in the particular action, and whether or not we thought we had a successful claim to make, and whether or not that was worth it. And that's kind of what we used as our sort of meter point.
I don't have too much else to add other than what Cassie said, other than, sometimes there are impact cases that are resource intensive that don't actually materially change the lived conditions of people's lives. And so you can have a really shiny legal victory that doesn't impact how people are actually experiencing the oppressive conditions in their lives. And that is another thing to think of in impact litigation. And we're just trying to make sure that we say community-centered and community-focused, because sometimes in impact litigation, the lawyers can just sort of run away with the plot. An additional complication to your question.
One thing that I'll say in my work, I have seven different lawyers and law firms that we will either refer people to or that I work with depending on issues. And in terms of this resource allocation, obviously as a union, we rely on member dues. We have a duty to represent members, but one of the things that we sometimes have to tell people is, I can't get you a lawyer for this. And there have to be times where we kind of tell somebody, I'm really sorry, and I understand that you feel differently, but if I send you to a lawyer, it's going to cost us a lot of money, and you're going to end up in the same place that you are already in. So we don't necessarily decide whether there's a case or not, but we have to decide whether or not to even refer somebody to a lawyer in the first place, or to tell somebody, you're welcome to get your own lawyer, but the union will not be reimbursing you your fees for lawyers. So.
Here's the mic. I'm sorry. How do you encourage commitments in the community organization? Like when you, sometimes my little experience is initially there is this whole, enthusiasm towards whatever you're trying to do or help, and after a while, and especially the type of people you work with, I'm talking of the people in legal aid, and they all have all kinds of issues, especially mental illness. And how do you encourage consistent experience and a consistent commitment to the cause or to what they want to achieve?
Yeah, thank you for the question. I think often of sort of our commitment and how we are showing up. And I think if you're expecting people to be committed, I have to be committed, and I have to be committed not just to the cause, but to the people whose lives I'm in relationship with. And so I think for me, this question really animates my life, but just approaching it in the reverse of how I'm showing up and how I'm committed and whether I'm committed to people's lives because I think there's a case that they can advance or an issue they can advance, or I'm really in relationship with people. And I find that if I am showing up with that spirit, that's the best thing I can do to encourage consistency from community members or from clients. But it is a question of where people are at, right? And what's going on in their lives. And I think being present for someone's life and being in relationship with someone means knowing them beyond the case, caring about them when they have an eviction, when they need $50, when they have a flat tire, when they don't have gas, when it's Thanksgiving and there's no money to feed their kids. And so I think that, the issue of how you are in relationship with people and how that looks sustainable for you is sort of a lifelong thing to navigate. And I don't know that I have arrived there yet, but for me, I think of that question in terms of how I approach it, because I can only control, my end of the bargain. Maybe a non-answer.
Yeah, I think that's one of the hardest things for me too, because so many of the communities that I'm working within have so many other challenges, as you mentioned, and so, I come into it, I'm getting paid to be there. I am, someone who I'm going home, I don't have any of the issues that they're facing, and I think that creates a real dichotomy and a real issue for me, and so I try not to have this expectation that they're going to necessarily, follow through, because they have many other things that they're going through and lots of other challenges that's not even related to the issue necessarily that we might be working on, but other challenges too. So I think, again, I really loved what Anna said about being invested in the people that you're working with as people outside of this particular issue. And that creates other issues too, like boundaries, and as Anna alluded to. And so how do you kind of maintain your own self and your well-being? But I do think having a lot of empathy, having a lot of an emotional connection to the people that you're working with, and having them continuing to inspire hope, which is something that Alyssa mentioned at the beginning of this symposium, but I think trying to be a source for some sort of solutions or hope for people in terms of what's possible. I think that's also really hard too, especially when the legal case is not great, but that's something that I try to do. But that's kind of how I approach it, I think.
Yeah. For me, I would say the big thing that I try to do is follow a rule of 75-25. Like if I'm talking with somebody, if I'm talking with a group of people, if we're going over issues, they should be doing 75% of the talking. I should be doing 25% of the talking. Just anytime that I'm dealing with anybody from the community, I need to be doing a lot more listening than I am talking. So
I also think about what we're doing to make spaces accessible. Like if I'm consistently saying community members aren't showing up, what am I doing to make spaces accessible? And in that first community group that I alluded to, that I started with some clients and friends back in Atlanta, I was the logistics chair, which meant that for all of our community meetings, I made sure that there was space. Every single person who was coming had transit or a ride to get there, that there was childcare, and there was food. And those four things, I think, for me, really formed me as an organizer in an ethic of how is it that we're expecting people to show up and what are commitments to people when they do show up. So things like having a hot meal, making sure you respect people's time, letting people know ahead of time what's being discussed. And I, every Tuesday night was on the phone making sure that people could pick someone up or get a ride, and making sure there was childcare. So I think often when we're asking people to show up, what are we asking people to show up for? And are we just asking people to give us their evening with no commitments from our end?
I think we have time for one more question, if anyone has last minute. Benedict, you win.
Hi, everyone. So this question, don't want to end things on a downer, but maybe you can twist it into something better. But for me, I see the law as a really powerful tool to pursue movements and really make social change, but also a limited tool in many ways, thanks to the Constitution, its interpretations, and other laws. So I'm wondering, when you're working with a community and a community member or organization asks you as the attorney to help them solve their problem with the law, and the law just isn't the right tool for that job for whatever reason, how do you communicate that? How do you still work with them to find other solutions? Kind of what's the approach to still staying committed to the community even when you can't bring your tools as a lawyer to help solve whatever issue they're trying to resolve?
So I don't tend to stop there. So if there's a legal claim that, is probably not going to be successful, I try not to have that be my end point. And if there's a lot of motivation within the community that I'm working with, that, there's something wrong, we want to change it, then there tends to be other potential options, whether or not sometimes they may not be that viable, but sometimes they are. So for example, there's policy change. There's additional community education that can happen. There's also advocacy outside of legal claims. So sometimes I might not have a legal case, but I'll still send a letter to a landlord being like, please don't, impound people's cars all the time in your mobile home lot, because it's not a nice thing to do. And sometimes it works and sometimes it doesn't. But I think sometimes taking those sorts of actions builds trust in the community and helps build relationships. And so I think that there's ways in which there's still things that you can do outside of, just filing a case. And I do think that policy change is one of them.
Well, obviously I have a different perspective on this because I'm not a lawyer. But anytime that I'm working with anybody, I always have in the back of my mind that eventually a situation might require a lawyer, but we're always thinking, what can we do without needing to involve lawyers? That could be, we could facilitate conversations with the people that need to be talked to. We can look for policy changes. We spend a lot of time advocating in Richmond. We spend a lot of time advocating in Washington, D.C. We have situations where we do need to involve lawyers, but so much more of what I try to do is, how can I help you help yourself, rather than how can I have a lawyer try to solve your problems for you.
Anything you want to add? Okay. I know the time is short. Maybe we can just take the last 60 seconds for a quick down the row to ask if you have advice, maybe a word or two of advice for especially the students in the room who might be interested in engaging in movement or community lawyering or organizing. Any advice? Cassie, will you start maybe?
Yeah, take my clinic.
There you
go. We do mostly individual representation, but we also talk about these topics. I think trying as much as possible to get the experiences of actually doing this type of work. I did a lot of social justice work when I was in law school, but didn't do any community lawyering work necessarily. And so I think if this is something that really interests you, try to intern at Legal Aid Justice Center, try to find other firms that are working on these issues, civil rights firms. I don't know if Danny's hiring interns, but maybe. But trying to find other folks who are working on these issues and talking to them and trying to get that experience, I think that's really essential.
I think for all the law students here, the question is, what is the nexus of your privilege and your oppression, right? So what are the ways in which your identity and your life is privileged, and what are the ways in which it is challenged, and trying to find the sweet spot of where you matter. And I would urge everyone, given the enormous privilege we all have, either as lawyers or to be in law school, to do work that matters. I think we need it. We desperately need it. There are people every day that are facing crushing burdens, and I think it is vitally important that, everybody go and do some good, right? And if that is not available in your professional life, or if it is also available in your personal life, I think that really part of organizing and part of movement lawyering is to be engaged in a cause that matters to you personally. And so if it is your community group where everyone wants more cops, or your neighborhood meeting, or your kids' school, or what books people are reading, I think that it is vitally important to be engaged, and be engaged when you are not the one with the most power, but you are one of the people in the room. And I think that sets you up to do this work when you have more power than other people in the room. And so I would just urge everyone, I know, it's cool to say, do what you will. I don't believe that. I think you should do something that matters. I think that there are crushing burdens that people every day around us are facing, and I think it's vitally important that we get engaged and do not turn away and do not look away and pick something that's comfortable.
For me, what I would say is I have 7 different law firms, like I said, that I work with depending on the issue, just because we have folks that need so many different potential specialties. I have a management law firm that I work with. I have a criminal law firm that I work with. I have an employee side law firm. I have a workman's comp lawyer that I work with, both on management side and on employee side. Again, without me being a lawyer, I can just say there are a lot of different specialties within the legal profession that can be tied to union work and can be tied to this idea of organizing.
Well, thank you all so much. I want to thank Alyssa for her leadership and all of the members of the Law Review, and a special thanks to our 3 panelists for giving such, not only of their time, but just such heart and honesty to all of us today. Thank you.
Thank you all. That was amazing. So Alyssa is going to come up and give a few closing remarks, but before she does, I just want to thank her on behalf of the entire Law Review for her hard work and dedication to this event. She picked the idea, she picked the speakers, she planned everything. So none of us would be here without her. She's very humble, and I can see she hates that I'm doing this, but she deserves it. So if everyone could just give her another round of applause. That'd be great.
It's really hard to follow that up, but I will try to. Hello and good afternoon, everyone. My head and my heart are absolutely buzzing with what we've talked about today, and I hope yours are too. Well, I think everyone in this room could spend another 6 hours talking about law and political economy and solidarity and community building. I do want to take a few minutes to wrap up the symposium and get you all on your way. I promise I will be brief and I will talk fast. It takes a village to do anything of this size and scale, so I wanted to extend my deepest gratitude and thanks to everybody that made this symposium possible. First, thank you to our guests and our speakers who shared their knowledge, passion, and expertise with us. You all are doing important work in your respective spaces, and it's even more work to share it with a broader audience and to get us excited and engaged about it. As Mr. Walrod said, organizing is moving from talking about the problem to doing something about it. And in every single presentation that we had here today, we had examples of how that can be done with concrete, actionable steps. I appreciate your time, effort, and energy, whether you're coming from, taking a couple connecting flights or just on the road in the city. I very much appreciate it. We would also like to thank Richmond Law staff and administration for all the work they did in preparation for the symposium. In particular, thank you to our resident expert, tech expert, Carl Ham. We owe a huge debt to I think the applause, speaks for itself. We owe a huge debt to him to make sure all things tech-related at the law school go as smoothly as possible, and he is the essence of patience and kindness with all of our law school's tech woes, especially today in all of our fun little, we're going to figure out how a microphone works briefly. Thank you as well to our invaluable staff up in the Dean Suite, particularly Mary Ruth Walters and Will Thompson, for their unflappable support with scheduling everything that happened here today, especially when I emailed folks probably 9 months ago saying the moot courtroom is mine on October 25th. I am also grateful to Volume 59 of Law Review. I see a couple friendly faces in the audience. You all have dedicated a significant amount of time to make this journal the best that it can be, and it's not something that I take lightly. I hope this day inspired you and helps reframe your perception on not only what a legal journal can do, but your role in it and what you can do in your life after you leave these halls. I would also like to thank my friends and colleagues on the Law Review Executive Board, Jamie Reese, Hannah, Aubrey, Kelly, Gwen, Melody, Connor, and Brady. The 8 of you stepped up on a very busy day, above and beyond your usual responsibilities to this journal. Thank you for your dedication to the Law Review and for all that you do in the Richmond law community. I am grateful to you and for you, and I know that you will meaningfully contribute to the legal profession in a few short months when we graduate. I'm also going to take a minute very selfishly to thank Professor Norris for his help and guidance in planning this symposium. I know he's not here in the room right now, but you all can tell him how much I sung his praises. As a bit of inside baseball, Professor Norris taught a seminar about law and political economy during my 2L fall that ignited my interest in LPE, and he has been an invaluable resource to the Law Review ever since I asked him if it would be just a little bit too weird to do a symposium about LPE. The lessons I learned from that class greatly impacted my perspective on what I should use my legal education for and what the symposium can do. I am grateful for our faculty, the UR Law community, and today's speakers who show us how we can help others build community and stand in solidarity, even when it seems too hard and too complex to know where to begin. And finally, thank you to all of you that attended today. While receiving CLE credits is important, especially the ethics credit that we just got, we do hope that you've also come away with learning something new or different. We don't expect you to change your life or your practice, but we do hope you walk away today with a new understanding of where the gaps might be in our laws and our institutions, and what we can do to better them going forward. As a professor, I may have already thanked earlier once told my 1L class, never let your skill exceed your virtue. We hope that whatever skills you have, may you use them to help others towards justice and to build a more equitable future. The Law Review Executive Board members will be around if you have any final questions or concerns that you would like to share with the Law Review before you leave today. If you haven't already, please pick up your CLE materials from the check-in table before you leave. The deadline is October 31st, and I want to make sure that you receive that for all the time that you spent here today. We wish everybody a safe and happy travels home and a restful and restorative weekend, and thank you for joining us today.